not interested to getting it set aside the interim order. Sorry, election in respect of the. But the pray, may I read the full prayer or only relevant prayer at prayer
Your
3?
contention is that prayer 2 and 3 have not been granted.
No, my lord. That is, I am not. I have not challenged it. I am only concerned about prayer number 3. The
Prayer number 3
non-consideration of the
is
prayer
for
number
conduct
3,
of
my
the
lord, I am
election.
before the.
Council, prayer number 3 is for conduct of the election in accordance with the amended bylaws.
My
Is
lord, I
that
think
right?
your lordship may kindly have the learned single judge order at page 19, my lords. Lordship may got it at page 19, my lord. But I am not because my lord, in view of the already period has been the election has been taken long back. I am not I am not seeking that relief to set aside the election.
Then what
I am
is the
only
relief?
said, beg your lordship. Your
What is the
lordship at
relief
page
you're
19
seeking?
of the order of the learned single judge. What is my prayer at 3, your lordship may kindly look at.
Yes, what is the prayer?
May I read, my lordship?
Please do.
The issue a order writ of certiorari quas the annexure D dated 13/10/2021 bearing number so and so passed by the second respondent declare that bylaw number 23 as per annexure B dated 21/1/21 passed by the general body of the third respondent is deemed approved as per the section 12(2)(a) of the Karnataka Cooperative Society Act and as per the amended section 28(a)(2)(1)(d) of the Karnataka Cooperative Societies Act. My lord, the pursuant to the amendment made by the cooperative, the enacted by the legislature, my lord, the general body passed a resolution, the in conformity with the increasing the director post from 15 to 17, and general body passed a unanimous resolution in conformity with the act, that is 28. Now, my lord, that is application, your lordship, annexure B. It starts from page 51, your lordship. The translated page 51 is the general body resolution, my lord, the lordship say. Well, annexure B at page 51. Translated copy, your lordship will get it at page 56. My lord,
Yes.
But the I only amendment of the bylaw, my lord, increasing the 2 director in conformity with the amended the provision of the by the legislature. That page 56 is the application given to the second respondent, my lord, on 28/1/2022. Then, my lord, he passed an order at annexure D. My lord, it starts from at page 66.
Council, when was the election conducted? When was the election conducted?
The election is over. My lord, I am
Yes.
not. I am not challenging. I am
How
not.
How many seats were election conducted for?
Not the election has been, no, it is question of amendment of bylaw in conformity with the
Council,
section.
how many seats were elections conducted for?
That is for only 15 seats it was conducted.
Absolutely. So therefore the election is already over.
Yes,
if
I
you
am
have
not
any contention, if you have any
sorry,
contention with regard to the election which has already been conducted, you'll have to raise it in an election petition.
My lord, I am not challenging the election, my lord. I am not challenging the result of the election. So far as already election held in respect of the 15 seats, I have no grievance because of the time has already left. I only said that amendment, I am challenging it. Even if it is my amendment is allowed, I am not asking the dishonorable court to go back to the election, because that is what your lordship may kindly see the order of the dishonorable court while issuing a notice. They said the appellant have clearly stated he will not challenge the election, but only confined to his with regard to the amendment of the bylaw which has been passed under. May I read the provision of the Cooperative Society Act section 12.
Annexure H has already been quashed. Is that right? Annexure H has already been quashed.
No, my lord, annexure H was, my lord, when the administrator was there,
Suo moto.
he passed the resolution.
Yes, that has been quashed.
Quashed.
Now what is your grievance?
Sorry,
Election
the
has also
bylaw
been
amended by
conducted.
the second respondent was challenged on the ground that while during the period of the administrator, he passed an unanimous resolution that has been challenged, that has been quashed.
Yes.
I am only challenging the annexure D. Annexure D, my lord, it starts from 66. Typed copy, your lordship will get it at page 68.
What is annexure D?
Annexure D, my lord, by the amendment of the bylaw, in conformity with the law enacted by the parliament, the state legislature, was rejected by him on the ground that the notice has not been served. My lord, the unanimous resolution has been passed, everybody accepted it, and he find without any justification, contrary to that, he said you may read the 68, my lord, the order of the second respondent, because his interest was he want to reject it, and he enacted a law for that is how he acted it. He is not prepared to accept the resolution, the accepted by the general body of the society. Now he rejected it. He making himself as a law that has been struck down by this honorable court. His order. Now this has not been considered by the learned single judge, my lord. That is anyway. Well, may I read that, my lord, the annexure D at page 68.
That was the very same amendment in annexure H also.
No, my lord, the H is the made by the joint registrar. He himself suo moto.
That is the only difference.
The suo moto was struck down by the court.
Correct. But
Now the general body resolution is was
just a
sent
moment.
to the.
Just a moment, counsel. What is the difference between annexure D and annexure H?
Annexure D is the rejection of the amendment made.
They had, the general body had made an amendment.
That was submitted to the second respondent.
That was rejected.
That was rejected. That is challenged in annexure.
And suo moto, the joint registrar or the
Yes.
Authority amended the bylaws.
Yes.
The suo moto amendment was struck down
Struck down. Yes.
because the general body had already amended.
Not because of that, my lord. The reason is not clearly given in the single judge's order. My lord, your lordship, if your lordship refers to rule 12, my lord, when suo moto amendment can be made, is referred to, my lord, in
12.6.
12.6. So an opportunity was not given to them. But 5 may be seen, 12.5, before looking at 6.
Yes.
If it appears to the registrar that any amendment to the bylaws of a cooperative society is necessary or desirable to give effect to the provisions of the act made thereunder, the registrar may, by order, may direct the cooperative society to make the amendment proposed by him in such manner as may be prescribed and within such time as he may specify. This was not complied, my lord, but this is not specifically stated in the single judge's order.
But then please see paragraph 4 of the learned single judge's judgment. Respondent number 3, union once again submitted proposal of bylaws for approval to respondent number 2, JRCS. Instead of considering the same, respondent number 2 issued notice and purporting suo moto to amend the bylaws. So therefore, it appears that it is because the bylaws had already been amended by the general body that.
Just clarify, my lord. If I tell your lordships the chronological list of events, my lord, which is submitted along with our statement of objections, which is at page 69, my lord. At page 70 is our list of dates. In fact,
in your statement
we had rejected the rejection was happened. Thereafter, once again, they submitted a proposal to reconsider the same rejected amendment.
Okay.
So that was not considered.
Now, what is
because there was already a rejection.
What is the statutory requirement that there must be 2 more directors?
Yes, ma'am.
That statutory requirement they had met.
Yes, ma'am. That amendment was rejected on the ground that notices were not issued to the concerned person.
Correct. Then again, they submitted a proposal.
Again, for the same amendment, they submitted a proposal, and that was not, nothing was done on that. Instead, the second respondent, suo moto, amended the bylaws.
Now that the suo moto amendment has gone, should not the second proposal have been considered and.
Lord,
approved
it has
with the
already
post-
been rejected is the case of this statement. It was already rejected. Your lordships may look at the dates which is provided at page.
No, already rejection is on the ground that notice had not been appropriate. What is the reason for?
Yes, my lord.
What is
Annexure R2 is the, I don't have the translations, my lord. Annexure R2 is the document at
There is
page
a, there
79.
is a translation for annexure R2.
I have not been supplied, my lord. My copy doesn't contain.
In the above
translation.
referred letter, you have submitted for bylaw amendment under Cooperative Societies Act 1959. However, notice dated 7/12/2020 general body meeting, proposed amendment is not mentioned. Since proposed amendment is not informed in the notice for the members' attention, proposed amendment cannot be accepted.
Yes.
Thereafter, if the general body met again and forwarded again for amendment, it has to be considered.
My lord,
This
that is
is-
not
this-
forthcoming, whether it is the same proposal which was sent or not is. not.
Even if it's the same proposal. It,
My lord,
the,
once it is rejected.
it is not, no, what prevents the same proposal being sent again, forwarded again?
My lord, because it was erroneous in that notices were not issued before the carrying out the amendment. My lord.
Therefore, the only requirement would be that a further general body should have been
Yes,
conducted.
yes. With
What do you
sufficient
say?
quorum, they should have amended the.
What do you say? Was the general body conducted where the amendment was a part of the agenda?
Yes, my lord, sir. That is why I have produced a
Because
resolution also
for-
I have placed it.
For general
Unanimous
body to be
resolution.
conducted for amendment, there has to be specific notice.
Yes.
Yes,
Has that been done?
yes.
Where is that? Where is that? The amendment with notice and agenda. There has to be a notice for the general body amending the bylaws.
Yes.
Where
Well,
is
that
that?
has been placed it that after that has been after the notice, general body has passed a unanimous resolution accepting it.
That will not do.
The
Notice has to be in the manner prescribed.
My lord, my learned friend made a mistake. Earlier was rejected. It earlier was not rejected by them. First time rejected is annexure D. That order I have challenged it. Earlier there was no
Where-
rejection.
Where is the general body notice for that amendment? Notice for the general body for in respect of that amendment that you say you carried out.
Yes, but that is in the notice itself. See, that the calendar of events it was mentioned. Will not the
That will not do, counsel. You must show us the notice.
I think your lordship says
It
first
may
time
not be
asked
correct to
it
say that
because
the amendment
earlier
was
the
rejected and, my lord, it was only after the rejection.
my
is
lord,
that
the
second proposal was-
rejection is I have challenged it. There is no only one rejection. There are no two rejections.
Counsel, you have
at all.
challenged the rejection, we understand. But for that rejection, the rejection to be set at naught, you must show that the general body had been conducted with due notice and that bylaw amendment was a agenda in that general body. Where is that notice?
My lord, that the general body meet the proceedings I have produced at annexure A.
Proceedings will not do. Please show us the
Yeah,
notice.
proceeding, they also said, my lord, the notice has been issued because the general body notice itself says it is not the general body. Notice,
Where is the notice?
that is my lord, the annexure A. That is issued on 1/12/20.
My lord, I don't have the copy of R2, my lord. May I just read R2, which is in Kannada, and then
Yes.
translate it, my lord?
Yes.
Everything will fall into place once I
Yes.
read R2, my lord. My lord,
That
May I just
your
give
lordship
three
may
dates, my
kindly
lord?
see the
Just a
that
moment,
was
just a
in
moment.
the
Just a moment.
last page 45.
So-
That
so-
was
so-
the notice was the general body with resolution the proposal on 1/12/20. Then election has been taken place on 23/12/20.
Just a moment, counsel. Where is this is the notice.
Yes,
Agenda is at
that your
page number
lordships are,
48.
your lordships are referring annexure A, my lord. The
Yes.
notice.
Yes.
That that
Page
is my lord,
50.
that is my lord, I think in page 38, item number 10, with regard to the amendment of the bylaw. That I have 1 minute, my lord, that has been stated in the translated copy. I will place it. The Kannada version is there. Then, my lord, your lordship will get it at page 50.
Mm.
No, the only second respondent interested to he passed his own suo motu bylaw, and now he has 1 year he kept it. But once I submit it, if it is not rejected within 3 months, there is a deemed approval. If the bylaw is the application of the bylaw, that approval is not rejected within 3 months, under the section 12, it is a deemed approval. It was passed an order after 10 months. Annexure E is the notice. The 112/20. Then the resolution copy is Annexure B at page 51. The board resolution.
Yes.
Then, my lord, thereafter, my lord, he has said he sought some particulars, we have produced it. Thereafter, the Annexure C, he asked to produce some more document. Your lordship may kindly see the Annexure B is dated 28/1/24. The rejection is Annexure D dated 13/10/21. May I take your lordship the provisions of the law, the bylaw, that section 12 of the Karnataka Cooperative Societies Act. But bylaw, amendment of bylaw as section 12 of the Cooperative Societies Act, your lordship may kindly see the.
Procedure regarding amendment of bylaws is in the rules. Are we
No,
right?
section, my lord, section 12.
Yes, my lord, that is in.
Procedure
section-
with regard to amendment of bylaws is in
Yes,
the
my lord.
rules.
Section 12 maybe, your lordship may, section 12.
Yes.
Then your lordship may 1A may be kindly be seen.
Mm.
Every proposal for such amendment shall be accompanied by such fees as may be prescribed. Different fees may be prescribed for different class of the cooperative societies. Then every proposal for such amendment shall be forwarded to the registrar. If the registrar is satisfied that proposed amendment is not contrary to the provision of this act or the rules and do not conflict with any cooperative principle, satisfy the requirement of sound business, will promote the economic interest of the members of the society, not inconsistent with the principle of the social injustice. So, justice. The period, he shall, within a period of 3 months from the date of the receipt of the proposal, register the amendment. If the registrar is unable to dispose of such an application within the period specified in the subsection 1, the amendment of the bylaw shall be deemed to have been registered. Then your lordship may kindly see, I have given an application at page 56 on 28/1/19.
Just a moment. Just a moment. Let us just interrupt you for a moment. Now, please read Rule 6. Page 178.
Rule 6. The Rule 6, your lordship, sir.
Yes.
The procedure regarding amendment of bylaw. Where
Yes.
cooperative society proposes to amend its bylaw, no such amendment shall be made save by the resolution passed by the 2/3 majority of the members present and voting at the general meeting of the society. No such resolution shall be valid unless notice of the clear 15 days with the text of existing bylaw, the text of the proposed amendment and reason thereof has been given to the members of the society in accordance with the bylaw.
Not given.
I have given it, my lord. It was on
Where?
1/12/2021.
Where?
The notice along with the bylaws copy was given for
Where
a
is that,
proposed
Counsel?
amendment.
Where
And
is that?
the
Please
meeting
show
has
us
been
that.
taken.
Please show us that.
But we have given it, my lord. Then I have the resolution was passed on 23. The general body was on 23/12.
On 7/12/2020, the notice you have given is at annexure
my lord, the
Just a moment, counsel.
yeah,
At annexure A,
annexure A.
please come to page number 49.
14.
That is the agenda.
Yes, my lord, 1 minute. 14.
To read and record the notice of the general body meeting, to present, verify, etc.
Yes.
And at page 50, regarding
Ma-
amendment of presently
Lord,
existing
that-
bylaws.
my lord, I
This
think
is
in
not
a-
in accordance with Rule 6.
Well, 1 minute. Then, my lord, I think at
Yes.
page 50, item number 10. My lord, it is
Passover,
not
we'll
date
hear it
is
later.
7th. No, it was typing mistake, but original document at page 45. It is 1/12/2020.
This doesn't show anything. Counsel.
That date, we along with that is not in disputed, my lord.
We'll
Along
hear
with
it on some
that,
other day.
please, my lords,
Yes,
please.
just after 2 weeks.
Number 2, Venkatram CR.
In this, we have made compliance of all the objections. With regard to updating updating the date of birth of
Sorry?
date of death of the
Hmm.
persons. If court permits, I will update either here itself
My
or
lord,
in the office.
I have not been served with a copy. Let,
Which one?
at
Please
least,
serve a copy and also get the details as the, because you don't say in
One
your,
one submission. GPA copy has already been provided to them.
no, that LR application or something like that is there.
Huh?
Is not. LR application.
LR application also served at, otherwise I will give you a copy outside.
please serve copies, counsel.
Ah.
Learned counsel for the
And I may kindly be permitted to update the death.
appellant seeks time to serve a copy of the LR application. As also to update the IA by incorporating the date of death. Yes. List after, please go through that list after 2 weeks.
Up to 1 week, because other respondents number 2 to 5, they are insisting for order on IA number 3.
Yes.
That application also is not being served upon.
May it please, Your Worship.
Was party in person.
They have filed one application, party in person. We have filed objections and it has been served on the other side.
Hmm.
This was a case where the wife had applied for divorce in the trial court. And then the court, in the MC petition, which was for divorce, the court has ordered to hand over the custody of the child to father. So
Now, here is a case where the child appears to be a child with special needs.
yes, now the child is.
We are not suggesting that the parties reconcile or live together. That is up to them. But cannot something be worked out for co-parenting so that the child's needs are met? Instead of fighting over custody.
That's what I
It's
was,
not
I was
possible.
thinking, my lords, what I would like,
Five-year-old child,
5-year child,
five-year-old child,
autism
ADHD.
special, right?
yes.
So what I was just thinking, my lords, one way of looking at it, subject to what the other side also tells. One is to look at from a holistic point of view as far as the child's welfare is concerned.
Absolutely.
And another is parting ways. I would like to speak to the other side. And then probably we can think of some negotiation between us and then.
Ways of solving the issue.
Fair enough.
Special child needs
Both parents in, any child needs,
Definitely.
merits. There is no second.
definitely, but then in the case of a special child, the need is even more. Therefore, if the parents can put the interest of the child first, we are not for a moment saying that they should stay together or
I would
come
be the
back
first
together.
person.
But is it not possible to work out some means of co-parenting so that
Your Honor,
child's
Your Honor, my submission is that from day one, when the litigation started or whatever it is, she is now feeling guilty that she will not come back because she has filed a false case. And
it is not a question of guilt
no,
or whatever. It's
Yeah,
a
my sub-
question
my
of
s-
what
my-
the child
yes,
requires.
that is what exactly. she's doing things that are unethical and yeah, Your Honor, everything is on record.
Counsel, you're not a counsel, that is a difficulty.
No, no.
Yes,
I
the
understand.
difficulty is that
Yeah.
we are not in a litigation
Yes,
among the two of you.
yes,
We as the bench, we are only concerned with the child.
yes,
And what would be the best interest of the child is the
Yes, that
only
is what-
concern that we have.
yeah, that is
So
what,
we are asking you,
there is a,
keep your differences aside. We don't want to,
Yes.
we are not considering an application for divorce. We are not also considering any cases of adversarial litigation at all.
yes,
We are only on the interest of the child. We are asking you.
Yeah.
If you want to part ways, there's absolutely no difficulty. We have, how best can the interest of the child be safeguarded is the only question. Therefore, we are asking you whether it is possible for some
Your-
means of co-parenting to be worked out.
Your Honor, this is what I'm saying. Co-parenting is not possible in this particular scenario because one is that the appellant, she is staying in Bangalore and she is staying alone. And this is my contention here that because the environment that is provided for the kid, and also after the judgment, she changed her address. And from 8 months, I'm not,
Staying alone be a problem? It is the mother.
yeah,
By itself, that should not be a reason for.
no, 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 she is staying alone and there are, I mean, there is no relatives or anyone there. I mean, the child should be access to all this environment, and that is what the medical report is submitted by the appellant herself. And that is the reason why I'm in front of this honorable court to tell that she is not working in the interest of the child. Whatever possible which is against the welfare of the child that can be done has been done. And that is why I'm in front of this honorable court. The litigations are false. Everything is on record. Everything is documented, Your Honor. And the order sheet, this,
Has
my,
the child been subjected to any psychological evaluation
yes.
by
I
the,
started it in Nimans before that.
by the, in these proceedings? Has that happened?
Yes, yes, yes.
Has,
No.
It has.
has it happened as a matter of fact?
No, no, in the proceeding, it
Just
is
a
not.
moment,
Yeah.
please.
In the proceedings, it has. That's where my
Only IAs for early hearing are there. Please put up the other applications. What is this to do? Okay. On some other day.
Please.
Serial number 9, my one submission. Serial number 9, my lord, I undertake to file wakalat on behalf of the respondent number 2.
Respondent number?
2, my lord. Prakasham Patil. I'll file it right now.
Yes. Please write.
Much of.
This is a matter, my lords, where on the last occasion, my lords passed an order that 4 crore 60 lakhs being the bid amount, which I paid in the year 2007, be repaid to me. So far, they have not repaid in spite of my, then my lord, what remains is the interest and conversion fee I have sought.
Yes, what do you say?
State, I'm for vide in the matter.
Who has to,
State,
who has to do the
State.
repayment?
State, my lord, immediately after the order was passed, my lord, DC has sent a letter to the concerned department.
Hmm.
My lord, I'm only told that there's some time being taken by the finance department to do some verification, my lord. It can be, can it be taken up after a week's time, my lord?
After
4 weeks
us
time was granted.
recording the permission granted by the government,
4 weeks time was
back.
granted, my lord.
Hmm.
Immediately after that, direction has been, letter has been sent by the DC, my lord.
Hmm.
And the finance department is doing, I'm told that there is some verification going on, that is.
I
the
don't know,
reason.
my lords, whether they are finding out if the treasury,
If it can-
there are funds or not.
No, regarding
Only verification you are required to do now.
no, verification, I'm told that they have to verify regarding the deposit, my lord.
Verify regarding deposit. I deposited the amount, my lords, in 3 installments before participating in auction as earnest money. I deposited 1 crore 4 lakhs 87,500. Then, my lords, that is on the, before participating. Thereafter, my lords, I paid 1 crore 15 lakhs on 27/4/2007. Balance amount 3 crore 45 lakhs I have deposited on 27/7/2007. After verifying all these dates, they granted permission to the deputy commissioner to refund the amount. And the date of that order also, my lords have noticed, that is on 20th September 2024.
Yes. What further
Lord, the
verification?
finance department is not a party. Maybe direction may be given. I'm told that it can happen within a week's time, my lord. If it can be taken up after a week's time.
Let the deputy commissioner be personally present, my lords, because he
The
is in
revenue-
fact-
Revenue secretary has already conveyed the matter to the finance department, I'm told.
This amount is also the principal
Then
amount.
nothing is
Principal
given,
amount
my
is-
lords. In the year 2023, a submission was made before this honorable court that they would come back within a week. They never came back.
Is it with regard to the interest and incidental charges that
No,
you,
the principal, as per the direction, the principal amount is directed to be deposited,
the principal amount has to be given, then
returned.
if
ma'am.
it is with regard to the other, with regard to interest and incidental charges, that time had been granted last time.
Yes.
That's also,
Interest and
No,
conversion fee,
That-
code fee, these are
On
the
that,
three.
on interest, it has to be heard, my lord.
then pay this. 4
Principal
lakh.
amount will be paid, my lord. I'm told that it may take a week's time, my lord. The finance department is not a party. I'm told that the DCA communicated the
Whereas
matter
I
to the
don't
revenue
think,
secretary. And the revenue secretary has already
Government
informed the
is a
finance
party.
department, my lord. In the finance department, I'm told that
I cannot
they
meet,
need some time for verification.
50
This is what
departments
I'm
in the
given to
government
understand.
are party.
I've told them, I've asked them how much time it may take. I'm told that it can happen within a week's time, my lord.
Verifying what? Because it is after an order has been passed with regard to the refund. There is no further verification required because it is, an order has already been passed. What can they verify?
That is
It
what I
is-
was informed, my lord. If a week's time may be given, my lord,
The learned.
My lords may kindly order personal attendance with deputy commissioner, my lords, then the money
Please.
will come.
The learned
if it is
learned
not done
advocate
within a week's time, then the presence may be ordered.
submits that a week's time is required for the return of the bid amount of 4 crore 60 lakhs to the appellant. It is submitted that though order has been passed on 29/2024, there is a delay and the matter has been intimated to the finance department of the government. There is still some delay in making the payments. Full stop. It is submitted that with regard to the interest and incidental charges also, instructions have not been provided as yet. It is submitted by the learned government advocate that the necessary will be done for payment of the amounts as well as for obtaining instructions with regard to the interest and incidental charges within a week. List this matter after a week. If the amount as ordered by the government on 29/2024 is not released by then, will appear.
Lord, I'm told that it is with the finance, it's the DC who has to,
The
is the
deputy
party, my
commissioner.
lord.
Which respondent?
Lord,
Deputy commissioner is the first
first
respondent,
respondent.
The
to whom
first
the
respondent.
amounts have been paid.
The first respondent shall appear in person to place the facts on record.
Please.
On give a date after clear 1 week. Take.
Grateful.
Please see that and
12th.
issue any, whatever copies are required. Yes,
Interim order be extended.
interim order shall.
Great,
remain.
great.
First respond. Records are necessary, my lord.
The
He is really relying upon the documents. which are-
appellant has retired on 22/2011. Therefore, there is no question of any reinstatement. The contention is with regard to a confession. That-
That aged confession, no way connected with the obvious evidence.
It is the only question. What is the confession? What is the confession is all that has to be looked into.
Records are necessary, my lord. Records are necessary, my lord. He is relying upon the documents which are before the court. Hence, the records may kindly be called for, my lord.
The confession is all on record.
Only confession
Already?
is there. Other records, he is relying upon the some other documents also.
Here also.
Hmm.
For
Hmm.
the trial.
Hmm.
For the, this call as well as for the update.
Hmm.
Then, my lord, for the first time, they produced the report of the inquiry officer. Because that was not part of the document, I did not write it along with the interview. I
Hmm.
have the document also facilitated in the meeting. I will not take even 2 minutes time or to let it circumscribe and file it in a due course. I think with that, I think may not be
Other-
necessary other documents.
ಬೇರೆ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
What is the documents that you require?
I'm going to only refer to that inquiry officer. I have got the copy, I will file it along with the.
Other records are not necessary, my lord. The records may kindly call for.
What are the records that are necessary? We are not expected to go into the facts of the matter. It is only a question whether that was a confession or not. Nothing else we can look into.
Please,
Is it
Manoj.
required? If you want, we can call for the records, but unless it is absolutely required, why go to that difficulty?
My lord, the primary reliance of the appellant is on an exhibit called R3,
Hmm.
which you'll also find page number 22 of the order.
Hmm.
But that exhibit is not produced before this honorable court. Maybe
What is R3?
R3 is, it is alleged it's a communication between the respondent one bank.
1 to 3.
To-
This
to
is
the-
not the inquiry report.
It's not the inquiry report. It's not the inquiry report.
What is not there?
Inquiry report is also not produced, my lord. It's not part of the appellant's compilation.
Where do the records have to come from?
From the
JRCS.
JRC,
JRCS.
from the first respondent office.
Shouldn't be a problem. Yes. Call for the records. list after a week.
Yes, ma'am.
Please, ma'am.
Within my understanding was to ascertain whether the records are before the JRCS or before the appellate court.
Yes, appellate court undi illa.
Just fine.
Not
Let
before
them
that.
file.
Wherever, yes,
The original authority, it is before the original authority.
yes. List after.
Yes.
Yes, we'll have to call for the records from the JRCS.
JSF.
JRCS.
JSF, myself.
Yes, call for the records from the JRCS, list after. Maybe 10 days. It's only here.
Oh.
Yes,
It records may not come within 10
2
days.
weeks. maybe.
why? Records don't have to walk.
No, 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 no.
Only thing 4 days holiday and all that.
Yes, 2 weeks.
2 weeks.
Lordships, I appear for in the connected matter, Rita Bill 73.
It is 12.3, my lord. I have to file second set of LR application.
Lordship may
my lord,
make one.
I have filed,
submission.
my lord, in the registry.
Lordship, could I make one submission, your Lordship,
Just a moment, please.
please?
I may be permitted to brought on record, I think my learners.
12.3,
my lord, WP 3788 of 22.
there is no 12.3, it is 12.2. 3788.
Sorry, ma'am,
Yes.
12.2. A1 of 23 for set aside the abatement of petition number 1 and A2 of 23 for limitation, A3 for 23 bringing LRs as record. I have filed, my lord.
You've already filed.
Already second set has been
Second set
filed.
has been filed.
Please.
Submitted by the learned counsel for the appellant that the second set has already been. Second set of writ petition is also not there. You filed everything.
Oh, please, ma'am, I have filed the entire.
Have filed the second set. Yes.
Lordship, your Lordship could permit me. In fact, in this matter, the first writ appeal, the KDB had submitted the other day. In fact, in my appeal, I have made an application seeking a direction where the National Highway authorities have utilized my land and they have neither paid me compensation and not they have deposited. In that context, I have filed the application seeking in a direction. And in fact, your Lordship, on the last occasion, these impleading applicants have submitted that they have writ petition is pending before the single judge, and as such it is. And I have amended the cause title also, and it is only my humble submission before this honorable court is that my land has been utilized. I am without any compensation or anything. 6 acre 24 guntas, which have been acquired by the KDB, wherein the National Highway authorities have taken a contention that they have filed as a objection to my application stating that it was given free of cost. And now I'm filing, I may be permitted to file the rejoinder to that objection, wherein I have clearly clarified, your Lordship, that where in one breath they would say that it is free of cost. In fact, the KDB, they themselves have made an application before the National Highway Authority seeking a compensation from the highway authorities to the extent of that 1 acre 16 guntas, which the highway authorities have said that it is free of cost. So I am left without anything, my land and no compensation, absolutely nothing, your Lordship. That is where I'm seeking. If that is, if they are seeking a time or anything, I would
On
make
what
only.
material do you say that it is free of cost? 6 acres, etc.?
KDB.
KDB.
There
it
is
is.
internal arrangement between the NHI and the KED, state government.
That is, the free of cost is by the
KEDB to the
KDB to
NHI,
NH.
correct.
Is quite another matter. What about the original owner of the property? Original owner of the property wouldn't give up
My lord,
6 acres free of cost.
Our only contention is whether KEDB has to pay them or NHI has to pay them, because
Whichever the act, there has to be, when land is acquired, there has to be payment of compensation.
Correct.
It cannot be acquired without compensation being paid. When is it paid? Who has paid it? It is, if it is under 28(2), then the KDB has to pay it.
Please.
Has it been paid? It is thereafter that the NH notification comes. And the NH acquires or takes it free of cost from the KDB.
from KED.
Therefore, initially, there has to be a notification
Correct.
and compensation by the KDB to the landowner. Where is that? Is all we have to look at.
Please.
This is the
One more submission.
long and short of it.
There is
One
no
more-
award.
One more submission, my lord.
Ah.
My learned friend, first respondent appeared before this Honorable Court, my lord. My lord, he has suppressed the material fact that I have been purchased from the first respondent under the sale deed, my lord, under
Who are
the
you?
sale.
The implication.
They have very
Including
clearly
my
stated in my
application has been allowed
objection.
By this Honorable
With
Court.
regard to property,
My lord-
you have been put on notice by the KD.
No, no,
No,
no.
no.
No, my lord.
Original owner has been.
He paid compensation.
No,
Oh.
No, my lord.
I am the absolute owner of,
Therefore, that is completely a different.
My lord,
question altogether.
I have filed a writ petition. That writ petition is also, my lord, not, that is why I tagged on to this writ appeal, my lord.
Yes,
3788.
we'll hear
When
that
we
as
fix the
well.
date for hearing, my lord?
Is it a writ petition that can be filed with regard to conflicting interests of title? That is another question. Anyway, your writ petition will also be heard for
Yes.
whatever it is worth.
Please.
If as a matter of fact, you have a contention that you are the owner of the property, should you not have filed a suit
My lord, we will
as
establish,
against them?
kindly fix the date for hearing, my lord.
Yes. Legalize of whom? To impede the legal aids of whom?
Legal,
Petitioner.
first petitioner, my lord. P.H. Ramchandra was died,
Are the second sets available?
my lord. Today, I have,
You've only filed it.
please,
Yes, next date will.
any date.
a short date maybe, please.
Please give a short date on this.
Grateful.
My lord, in this appeal, I appear for the appellant. Lord, some inconvenience to senior has placed for a short accommodation.
In fact, more than 3-4 times the matter was heard.
Any day next week, my lord. It is a small point.
After a week,
Yeah, please, please.
the learned counsel for the appellant seeks a short accommodation list after a week. Balance of improvement charges with
So the-
1.5%
Some instructions in
interest.
this case, my lords, because I did not prosecute the case before the learned single judge. I'll seek instructions and I'll make my submissions.
There was, improvement charges were demanded. Part of it was paid,
Improvement charges were demanded in 2011.
correct?
There was a circular at that point of time based on which the demand was made. Subsequently, that circular was quashed by the learned, honorable single judge.
Hmm.
After that, another circular was issued, that was also quashed.
Hmm.
Subsequently, another circular was issued, which was upheld.
Hmm.
But there it was held that you cannot insist on payment of betterment charges for issuing khata. I was before the authority for issuance of khata.
The finding was that payment of charges, the payment of the improvement charges cannot be a reason to withhold the change of kata. That's all.
It cannot.
That's all. But it was, the question whether the betterment charges are to be paid or not now appears to stand settled. If they are to be paid, their demand is correct.
Learned single judge had passed the order against which the other rent appeals are filed,
Hmm.
challenging the upholding of that circular.
Hmm.
So
Oh,
I'm
those
tagged-
are pending,
Those are pending. I'm tagged along with that because I followed the same order and learned circular disposed. of.
which is the case in which that upholding is under challenge,
The other three writ appeals.
all three of them.
1581, 2247 and 6869, all of them are challenged. In my case, following that single judge's order, my petition was disposed of, but my relief of kata was not done. In fact, pursuant to the interim order, I even deposited the balance amount. Kata is yet to be issued to me.
Why is the kata not issued?
Because I will not.
Kata could not have been, the change of kata could not have been denied even if he had not paid the balance amount. You ought to have changed the kata, then demanded it from him. That is the finding even by the learned single judge.
There are two different issues.
Then why is the kata not
I will assert.
changed?
Fine, will not, I will assert them.
Yes, the other issue is to be heard in the other three appeals. Now, in the first appeal, he says he's,
No, but actually, my only, what I gather, please do not see.
Hmm.
They have sought only, the challenge is only related to the tax aspect.
no, whatever be the aspect, the finding of the learned single judge is that even if the taxes, I mean, the betterment charges are not paid, the kata cannot be withheld.
That rule itself was struck down in the.
Therefore, now what is the reason for not changing the kata in respect of the first one? He says he's even paid the balance.
pursuant to the interim order passed by the Honorable. I will assert on this.
Yes, if it is not done, see that it is done immediately, because the challenge in the other writ petitions, I mean, writ appeals, is with regard to the finding of the learned single judge, not by you, but
Yes.
by the petitioners in the writ petitions, not by you. Therefore, as far as you are concerned, the learned single judge judgment has become final,
Unless not challenged.
unless not challenged by you.
They are relying on it, my lords, because 200 and 250 was upheld. They are relying on it. The condition of, precondition of collecting it before issuance of kata was struck down, which is not challenged.
That is not done, then it has to be, kata has to be changed now. Yes,
I will assert on these blocks.
Learned Counsel, writ appeal 729 of 22, the Learned Counsel appearing for the appellant submits that in spite of the directions issued by the learned single judge in the judgment under appeal in the connected appeals, the change of kata has not been effected in respect of the property covered in this appeal. It is submitted that pursuant to interim orders passed by this court, the balance of the betterment charges have also been paid by the appellant. The Learned Counsel for the respondent seeks a short accommodation to get instructions in the matter. List on.
Lots about 3 weeks. Lots I have to assert on lots. Only pray for you. Have to call them lots.
If it is only to ascertain, we'll list it after 2 weeks. If it is to comply, then we'll list after 3 weeks.
2 weeks.
2 weeks. So there is no assurance that compliance will be there.
I
Let
will
us see.
assert on that. If it is, I'll tell them, I'll instruct them.
Please, no, that was only in jest. List after 2 weeks. Rural candidate,
Lord,
Type
role
text.
candidate, my lord.
certificate.
Certificate, because, my lord, here, my lord, the division bench also, my lord, in the similar matter, has held that, my lord, the person who, my lord, completed in various schools, Lord, from 1 to 10, Lord, that has to be considered. That is what, my lord, the division bench order, my lord, says. Lord, here,
Where did you do your first to 10th?
Lord, Lord, I completed in the year, my lord, 1994. Lord, that time, Lord, kindly see annexure J, my lord, page number 94. Lord,
Just a moment.
the population of the, my lord, area was fixed in the year 2001 itself, only, my lord's 91, 47,000. And 2000
Annexure?
Annexure, my lord, page number 94, annexure G.
Yes, what does it
Type
say?
copy.
Is there a translation?
Translation which has been given.
Yes.
That 95, my lord, the translation is at 95, my lord. Lord, the area of the population was, my lord, on then that day was 91, 47,000. And 2000 was 52,067. So she has completed in the, my lord, the SSLC in the, my lord, in the different school of the, my lord, Kollegala district. In the year, my lord, 94, our SSLC was completed. Lord, the same was, my lord, and the, my lord, the appointing authority says, my lord, she's not suitable for the typist. Lord, but earlier to that, my lord, she has worked in the fast track courts almost from 2005 to, my lord, 2009.
Which is the order under challenge?
Lord, and that is annexure. L, my lord.
Annexure? L. Probation, discharge of probation.
Yes, my lord. And no note, because only, my lord, straight away, without, my lord, given a holding.
Suitable to hold the post of
Yes, my lord,
typist.
holding the
Said-
inquiry, without holding the inquiry
Subject.
also, my lord, this order came to be passed. Even there is no
What
inquiry,
is the requirement of inquiry
Not
when it is
required,
a
my lord.
discharge of a probation?
not required, my lord, also, my lord, because it says it's not suitable. But earlier to that, my lord, I worked in the, my lord, same court for almost 5 years as a typist.
That is another matter, counsel.
But only here says, my lord,
Non-suitability is the only ground on
suitably
which
is
a-
the, my lord, criteria that I have given the, my lord, the work, because under the rural my lord, rural area, my lord, reservation, I've applied and I've got this, my lord, post. Lord, then they said, my lord, it is the particular area where I've studied is not coming under the, my lord, the rural area. It is a town municipal. Lord, That is what the, my lord, but detail order, why I am not suitable was not even forthcoming in the, my lord, impugned order.
You are not coming under that category.
Lord, I have applied in that same category, my lord.
Because of the certificate, you are not coming in that category.
But because, my lord, yeah, before, my lord, passing the order, my lord, how it has been come to the conclusion that, my lord, it is not come, because I have produced the document before the, my lord, the court also. Kindly see the, because on the criteria was fixed, only the population also been, the criteria of that, my lord, the area which comes under the, my lord, population less than 50,000, then it will be considered as a, my lord, rural area. More than, my lord, 50,000, it will consider as a, my lord, the town municipal or any city municipal or any other municipality. That is the, my lord, notification of the government says also, my lord.
Why do you say that you've not put on notice? There appears to be a show cause notice.
Show cause notice issued, my lord, I challenged that my lord, by way of writ petitions earlier before this court also. My lord, subsequently, the direction is given later, my lord, to hold an inquiry, but nothing has been done, my lord. Straight away, the impugned order came to be passed to discharging me, my lord, from the said post.
Yes.
Hello. Waiting for the respondent number 1.
Yes.
Hello,
Yes.
waiting for the respondent number 1.
Yes.
Hello, when she was appointed, my lord, the appellate, my lord, and then we had sent for the document verification with the concerned department. They had given an opinion that it did not come under the rural category, rural area, based upon the information. Based upon that, we issued a show cause notice stating that you might have submitted a false certificate and please reply to the show cause notice. Then against the same order, she has given a reply to the concerned authority, to the department, to the authority. And the same was challenged before the court, my lord. In a writ
The show cause notice was challenged.
And at annexure K, my lords, at page number 96. my lords.
Yes.
Page number 97 is the relevant portion. They sought for a withdrawal of the petition. So that ended the matter, my lord. But however, my lord, as the department found that she was unsuitable for the work, my lord.
Oh, this was not in pursuance of that at all, according to you.
So then we issued an page number annexure L, my lord, page number 98.
Just a moment. When was the show cause notice?
Show cause notice at page
Date. Show cause notice dated 22/10/2013.
please.
22/10/13. Yes, what is the
22,
period
10,
of?
20, annexure F, my lord, page number 77.
So that, the challenge was rejected on 8.
Lord, it is not rejected. My lord, I have sought liberty to, my lord, in between, there is no stay order has been granted by the, my lord, Ranjit Singh judge. Lord, then what happened, my lord?
Counsel, it is a show cause notice,
Please, my lord.
which is normally not entertained by any
True, true, my lord.
constitutional.
That's why, my lord, when
Therefore, it
order
was
came to be
closed.
passed, my lord, I withdraw it. That's all, my lord.
Any-
There's no
anyway, the writ
adverse
petition
order
was-
has been passed by the Ranjit Singh
The
judge.
petition was dismissed as withdrawn
On,
on
yes, please.
8/6/2015.
Yes, my lord.
Yes, then when was the order, annexure L is on?
7/8/2015, my lord, annexure L, page number 98.
Yes, what do you say in your objections with regard to that?
Page number 100, my lord.
Paragraph number 8 here stated, the
Hmm.
respondent submit the page number 103. The respondent submit the appointment issue was still in the probationary period, she has not been confirmed as a permanent resident. The probationary period had not yet been declared by the office of the first custody. The petitioner was under probation, and the petitioner can be discharged from his or her at any point, at any time without giving clear notice under the Proceedings Rules 1956. There is no violation of police services by passing the interim order. Because we have exercised the power under Rule 6 of Karnataka Civil Probation Rules.
Yes, what does the rule say?
Discharge of a probationer during the period of probation. Notwithstanding anything in Rule 5, the appointing authority may at any time during the period of probation discharge from service probationer on ground arising out of conditions, if any, imposed by the rules or in the order of appointment or on account of his unsuitability for the service or post. But the order of discharge, except when passed by the government, shall not be given effect till it has been submitted and to confirmed by the next higher authority. Rule to my, sub-rule to my, any order discharging a probationer under the rule shall indicate the ground of discharge, but no common proceedings under the Karnataka Civil Services Classification Control and Appeals Rules 1957 shall be necessary. So we have exercised power under Rule 6(2), my lords. As we found the unsuitability for the post, my lords, we are discharged from the service. Relying on the judgment, where even if we have, the inquiry did not proceed further, my lords. We have stopped the inquiry, we did not proceed further, my lords. So the order was not a stigmatic, my lords.
Is it connected is the only question, because the writ petition stands withdrawn on 8/6/2015, 7/8/2015, the discharge is passed. Is it connected? Is it because of this is the only question. Otherwise, you're right, discharge of probationer simpliciter you can do. But there must be some material on which you base this, this finding that she's not suitable. Normal situations, it does not happen. It is, unless there is something, unless her service is completely unsatisfactory, normally it does not happen. Which is why we are asking you, is there any connection with this 8/6/2015 withdrawal of the petition and 7/8/2015 discharge? No, what are the decisions on the point? Does it?
But they are contending that the contending the order was punitive matters.
No, it is not punitive. We agree with you, but that it is not punitive. If it is a discharge simpliciter, it is not punitive. But if it is discharge simpliciter, must it not be based on something? When was your appointment as such?
Lord, earlier to this, my lord, I worked for 5 years in the same court as a typist. Lord, 2011, when notification came, Lord, I was appointed by virtue of the notification. Until 2015, I worked as a.
When were you appointed pursuant to the notification?
Lord, 2011.
2012.
11.
7/4/11. So if, as a matter of fact, what he says is correct. 7/4/2011. Till what is the period of probation? 2 years. Was it extended?
No.
Was it extended? It was.
No.
Well, because the rule says that until it is confirmed.
Correct. No, was it as a matter of fact extended for unsatisfactory performance? No, not done. Well. Is there anything on record which shows that there was unsatisfactory performance? The statement of objections does not say anything, which is why we are asking you.
Rule 5(2), my lords, says that the probation shall not be considered not satisfactory.
Correct. Absolutely. But then only because there was a show cause notice in the middle, we are asking you whether there's anything to show that the performance was not satisfied, that she was not suitable for the post. Please verify and let us know. Otherwise, it appears that because of the close proximity, that is all we are asking you. Yes.
Please.
Learned Government Advocate C. I'm sorry, for Learned Counsel for R1 seeks a short accommodation to get further instructions with regard to the unsuitability of the petitioner for declaration of probation. List. After a week, After, yes,
Any,
of the appellant, not petition.
oh, please.
Appearing to the appellant, my lords. I pray for a short accommodation. On the last date, we were asked whether a deposit has been made before the reference court. I'm still awaiting instructions with respect to the same. It's a 1990 acquisition. There's
38/1996.
99, please, ma'am, 1996 acquisition. So
The amount deposited in the civil court according to you on 38/1996.
please, we were asked to place on record the proof of the same. I'm awaiting instructions, my lords.
Is there anything to show that it has been done? You must have some kind of material.
Please,
Page number 251 may kindly be put forward. Where 22/3, there was no award was deposited.
Just a moment, just a moment. 270. Page number? Individual vouchers in respect of lands acquired and taken possession by the housing board at different survey numbers. Addresses mentioned in the vouchers are as available in the office records. Awards are made in one common order. Copy of the award is enclosed with check bearing number so and so for 5,93,790.
Right.
Yes.
22/3 survey number is concerned. Absolutely, there is no deposit made by the
22 bar
there are 3 survey numbers involved in the present petition. 22/2.
22 bar 2A, there is 1575. Amount to be deposited is 75,600. Amount to be sent to Tahsildar is 1575. 22 bar 2B, there is amount 2 lakh something.
22/3 and 22/4 is concerned, there is no deposit.
Just a moment. 5,93,790 to be deposited to the court. 6,300 to be sent to Tahsildar.
But of all the profits.
Survey number 26 bar 11. So and so check number deposited on 15,998. Survey number 26 bar 8. Check number so and so 31,594. Five lakh 93,790. That is this amount deposited on 28/96.
I await instructions, my lords.
More sufficient.
Hmm.
Number 22/2B is concerned.
Hmm.
Their submission is that entire land has been acquired by them. And in this regard, the annexure C is saying that only 24 gutas. The typed copy is different from the original copy. And they may be directed to produce the original acquisition certificate copy. So to ascertain the extent and boundaries of the property, 22/2B is concerned.
What is it that you're relying on?
HSC, madam. HSC,
Hmm.
original copy mirror.
Hmm.
It is 1 acre, 35 gutas, 22/2 in Kannada words it is there. Page number 83.
22 bar 2 is in page number 83. Hmm.
As far as the typed copy is concerned, survey number 22/2B, which is the subject matter of the present dispute,
Hmm.
it is 24 gutas. Page number 87.
Twenty-two bar 2 is 0.24.
Kannada words it is there. Extent of the land, 1 acre, 35 gutas. General notification they have placed. It shows different measurement.
22 bar 2B is from Narasimhaya.
According to this, my lord, 24 gutas. Original gazette notification is concerned, 1 acre, 35.
I'll clarify with respect to everything on the next date, my lords. It may be had,
Learned counsel for the appellant seeks time to get clarifications with regard to the extent of land acquired by annexure C in, from 22 bar, from survey number 22 bar 2B, as also to get instructions with regard to the deposit of the awarded amount in the civil court on 30/8/1996. It's after 2 weeks.
Survey number 22/3 and 22/4.
In respect of survey number,
22/3 and 22/4.
in respect of survey number 22/3 and 22/4. Yes,
The interim order may be extended.
interim order shall remain in force till the next date of hearing. Yes. 2 weeks, 2 or 3 weeks. Ex-servicemen.
Yes, this
of
resumption, my lord,
agricultural land. Tahsildar ordered resumption on 15/11/2012 by annexure. Tenants appeal dismissed. Learned single judges also upheld.
Ah.
3 concurrent findings. Occupancy which was registered by was set aside by this court. The contention is that there is no written lease.
This matter, my lords, was decided by the learned single judge under 227. You lords kindly take page 52 of the paper book.
52.
52 of the paper book, which is the order of the learned, part of the order of the learned single judge. Though the writ was under 226, questioning the statutory order under section 15 of the Land Reforms Act, the learned single judge confines the examination of writ proceedings under 227 and says so. Lords may kindly take page 52.
52 may not be the correct page.
The writ petition, writ appeal papers.
Appeal, internal page 23 of the order, my lord, which my learned senior is pointing out.
Ending page 52 is not that. Maybe
page
there's some, just a moment, just a moment.
Internal page 23 of the impugned order, my lord.
Yes,
It's after quotation of the judgment. Page 52. There's a lot of force in the vehement contention of Sri Sridhar Prabhu appearing for ex-serviceman that though Article 226 is also employed in the pleadings of the petitioners, the petition has to be treated as being only under Article 227 of the Constitution, which vests a limited supervisory power in this court, and therefore a deeper examination of the impugned orders, unlike in appeal, gained support from the appellate court's decision in Sadhana Lob's case. This judgment has absolutely no application. What was challenged before the learned single judge was the order of the Tahsildar and an appellate order of the Assistant Commissioner in exercise of powers under section 15 of the Land Reforms Act. It is amenable to writ jurisdiction under 227. The prayers were also to quash. Now, because of this observation, the learned single judge limited the consideration of my challenge only under 227 under supervisory jurisdiction. Now, referring to this, when the matter came up before your lordships in appeal, one friend who was on caveat took a contention that this appeal is not maintainable. It's on account of that, lords, I have to satisfy the court that this appeal is maintainable. But you should also point out, incidentally, the learned single judge who dealt with this has himself rendered a judgment recently where he says an appeal under 227 is also maintainable. But apart from that, notes the matter is covered by a series of judgments of the Supreme Court which says appeal is maintainable. So I'll have to first satisfy the court that an appeal is maintainable. Which may I start?
Yes. Because I have to, my lord, show how I am saying that it is not meant. I'll not take much time. I'll take 5 minutes, my lord. I have filed detailed preliminary objections. I'll not, my lord, repeat what I have said.
Thereafter, my lords, after we
Thereafter.
filed our written submission, court had expressed that it will finally hear and dispose of on both the issues. Let's, lords will take it up at 2:30, we'll commence our arguments.
Yes.
Yes, we'll just.
First, I have to satisfy.
2:30, there are other 2:30 matters listed today.
We'll wait.
We'll make an attempt.
Yes, we'll wait for our turn. Or whatever.
We cannot assure you when it will.
There are
be
3
taken.
matters I'm told, my lord. One is the 2:30 matter plus.
Your lords have it on 7th or 8th. my lord.
Sorry,
Could your lords have it on 7th or 8th immediately after the?
At 2:30, my lord, if your lordships. Allah, the only thing is, my lord, I am about 83 years old now. The whole exercise will become infructuous. I am a ex-serviceman. Let me, my lord, get in some set. That's all, my lord. I am a senior citizen. I have
My lord, one submission, my lord. Serial number 42, kindly adjourn on next week.
Yes. Shall we rush through the list and come back to the 230 matter? Okay. Early hearing. Can it be on a date?
Yes, ma'am. Any date,
Yes.
IA may be allowed and
Yes,
date may be.
IA is allowed, list on. Please give a date.
Please.
All the respondents are served.
Yes, ma'am. All are set.
Yes.
Arjun, allowed. In this case, my lord,
606
I filed
days.
application for recalling, my lord, for dismiss for default.
606 days delay.
Yes, my lord, that I have explained, my lord. I have explained, I have filed affidavit before this court that the dismiss for default for non-compliance of office objection, any condition may be imposed, my lord.
Yes. Heard the learned counsel for the applicant. In view of the averments in the affidavit filed in support of the application, the delay of 606 days in filing the application for recalling the order dated 8/11/2022 shall stand condoned. IA 1 of 2024. The order dated
8/11/2022.
shall stand. Recall, what do you say? In item 21.
Dismiss for default, recalling. Recalling,
There's an affidavit.
non-compliance on serial number 21.
21, the 606 days delay, he says it happened in his office. Therefore, we are condoning the delay. Recall can also be allowed. Yes, IA for recalling allowed. List after 2 weeks.
Please.
Office objections are there. Office objections are there.
No, for office objection for that petition, I'll comply within 1 week.
Yes, the main writ appeal.
Writ
There
appeal.
are office objections. Please comply with the office.
Please,
objections.
22 also say,
Yes,
connected.
same order there. Yes. Please comply
Please,
with the
I'll
office
come,
objections. We'll
come,
list
please.
it after that.
Afterwards, after compliance, we'll be listed. Respondent will always.
Hearings. Office objections to be complied. 2 weeks time. 2 weeks time, run. 14%. Oh, there is an office objection in the memo. Memo for withdrawal. Can we dispense with the compliance with the office objections and accept the memo? What is the office objection in the memo?
Non-service of other.
Provided it is not that it is not properly signed. That's probably why she's not come also. She wants to withdraw it then. Yes. If it is, otherwise, if it is something which can be overlooked, we'll do that and accept the memo. You need not wait. Yes.
This is lot, 45 and 40. Appellant has executed deed of confirmation deed during the pendency of the appeal in favor of respondent number 5 and 6 that I have produced. My lord, this is the property which is granted by land tribunal. There afterwards, my lord, that they have challenged before the deputy commissioner. Deputy commissioner rejected and ultimately, my lord, learned single judge also rejected. They have come before this court. And the appellant before this honorable court has, during the pendency of the writ appeal, has executed deed of confirmation in favor of purchaser from the respondent number, my lord, 1. And thereafterwards, my lord, that they have the contesting appellant has died, leaving behind his children. His children has brought on record. But this writ appeal will not survive. If at all they have got grievance, they have to challenge the deed of confirmation
No, but
executed.
they are represented by a council.
Those.
They have, council has to be heard.
Any good.
Listed on submitted.
Please.
Please call the earlier item once more.
24 and 24 surplus.
Yes, both will list it up. on submitted. You are the party in person. What is the office objection in your withdrawal memo? You are seeking to withdraw the writ petition. I mean, the writ petition.
Yes, ma'am.
You're seeking to withdraw it.
No, it has been decided. And in 2012, it has been decided.
You filed a memo to withdraw. Withdraw what?
No, sir, no, I have not, no.
Fine. List it on some other day. Please find out what the office objections are. We'll list it on another day.
No, as soon as possible. Little early. Thanks.
2 days it cannot be.
Okay.
Yes.
Right, before the respondents. But this.
All kinds of office objections. Only translation. Synopsis, better typed copies, etc., etc. Yes.
What had happened was, earlier, in fact, some talks were going on regarding settlement of all these three cases because all the respondents have retired from service. But now, my lord, that the calculation, along with the calculation, when they produced the board, the board resolution, it was in Kannada. Now, ultimately, it has not been worked out, my lord. In this case, all these documents are not required translation.
Not required. Yes,
Josh can post it for any matters to the authority.
yes. District for hearing, the office, it is submitted. That necessary copies, copies of, translated copies of necessary documents will be made available at the time of hearing, as and when required by court. List or office objections are therefore dispensed with, list or give a date. Yes. There are also several office objections.
I'm appearing for respondent number.
My lord,
It's complied,
I'll comply during the course.
2 weeks time granted to comply with the office.
My lords, during the course of the day, I'll comply, my lords. It may be posted some date.
My lords,
Bill
I'm
number
appearing,
20 is no more, my lords. So we have filed application.
Yes.
my lords, I'm appearing for respondent number 2 in this matter, my lords. I undertake to file my wakalat, NOC wakalat in this case, my lords, for
Please
respondent
do
number.
so. Please do so. We'll give a posting in the matter,
Much obliged. my lords.
but at the earliest.
Please.
Yes.
My lords, I appear for the appellant, my lords. On the last occasion, the state had to file their objections. They are yet to file.
Weeks time.
May I request for a date, my lords?
2 weeks, please post after 2 weeks.
My lords, interim order may be extended. Much obliged.
Tomorrow shall be.
For the appellant, respondent number 2 has to file their affidavit.
Notice to LRs of deceased appellant number 1 is dispensed with. Yes. Objections? Just after 2 weeks.
Date may be fixed out.
Notice to R8, R11, first time. Weeks time.
Appear for the response in this matter, it's a state appeal, my lord. The bringing the LRs of the respondent number 45, my lord, that application is filed by the government. That we do not have any objections to that, my lords, to bringing LRs of the respondent 45. And with regard to other objection is, my lord, Madam Suman Baliga have filed LRs.
Commissioner Lord, has happened is, we are working over there. Now the learned single judge has
partly allowed the petition of the contesting this point. They said to formulate the C&R. Actually, what has happened is, Your Lordship, the district hospitals have been now attached to the medical colleges because MCA regulation says that unless you hold the requisite infrastructure of hospital, the NCA will not give the permission. On that count, they have only given the permission to utilize the hospital. Insofar as teaching staff is concerned, we have no objection since the petitioners have been directly recruited to the teaching institute. The post which is existing in district hospitals are as per C&R rules is the Health and Family Welfare Department. We have been promoted and we have been transferred over there. Now, by virtue of the learned single judge order says that since the hospital is handed over to the medical education department, these people have to be reversed. By virtue of that, we are under the reversion. Please, Your Lordship can maintain a status quo for this.
No,
Please
no.
done.
Why?
Around 30,
My lord,
30 district
matter is-
hospitals have been
Hear it on the minutes. Yes.
Please, my lord, we are also ready in the matter, my lord, since it is listed in the orders. If my lords can take up the matter in hearing matter, let it come in the, yes.
What are the office objections?
Objections are with regard to my lords bringing the LRs on record that for the respondent 45, that my lord, the government have filed appeal application. I do not have any objection. The other respondent, my lord,
I have filed.
Madam Suman
We are
Baliga have filed.
working in the hospitals now.
Parents Council, you did not move it, it came up in the orders.
Yes,
Yes. Learned, council.
Recalling application.
in the interaction, my lord, there is a one more order, my lord, passed by the
What is the recalling?
They say that we are within a stipulated date, we have not complied because we have freshly included.
Now have you
Now,
complied?
we complied.
You're sure?
Yes, I have complied.
Yes, the
I
IA
complied.
number, writ appeal number 850 of 2022, IA number 2 of 2023. It is an affidavit and petition in view of the governments in the affidavit filed in support of the application. The delay of 12 days in filing the application for recalling shall stand allowed. IA 1 of 23, having heard the limit for the applicant, the order dated 21/11/2024. The order dated 21/11/2022 shall stand recalled. All of his objections shall be complied with. If not already complied,
We are not party before the Dhanush single state. We have.
if not already complied with, list on given near date. Can be.
no objections.
Yes. In writ appeal
977 is the state of.
2022, IA 1 of 2024, IA 2 of 2024, and IA 3 of 2024 shall stand allowed.
And another objection is not that Madam Suman Baliga have filed wakalatnama, but there is,
Not state.
seal is not forthcoming is the only objection from my instinct. Madam Suman Baliga have filed wakalat for the institution.
Did not been served. No, 45, is anybody taking notice for the LRs? You will
Please,
take
Lord,
notice.
I'll file my wakalat in respect of, yes.
Submits that he takes notice on behalf of the LRs of deceased respondent number 45. And that wakalat will be, and undertakes to file wakalat. In the above view of the matter, the yeas are allowed. 1 of 24, 2 of 24, and 3 of 20. Yes, list on
So that
7/11.
the admission law.
Let it come,
You'll have to carry out the necessary amendments.
please,
Amendments will have to be carried out.
that my learned friend.
Yes. Filing. Who states appeal? What about the delay in filing the state's appeal? Can it be controlled?
Lord,
Is everyone on record?
Everybody is, because the petitioners are my contesting respondent. We are coming for the first time for
Lord,
including.
directly, my lord, the connected matter, my lord, have directly come to this,
We sought a-
this honorable court, sought permission and, please, my lord,
Tell us whether the delay can be controlled.
121 days, my lord. That can be condoned and matter may be heard and disposed of. Merits. my lord. 33, my lord, I am also appearing one of the connected writ appeal, my lord.
My lords, I appear
Objections
for
are, my
the
lords.
respondent.
Objections are, my lord, that most of the respondents, my lord, are represented by the councils, and my lord, we have already
Yes.
will
What else? Any other?
some of the respondents, my lord, they are retired from service.
No, substantially served. Can we hear the matter on
Substantially,
merits?
can be
Yes.
all the petitions.
We have served for 8, my lord, and 2 are we have filed a memo, leaving the death certificate. So far as other remainder of 10 respondents, they are retired. And therefore it's a matter of.
What would be the, what is the subject matter of the appeal?
Promotion.
Therefore, retired hands may not have a
Yes.
stake. It is submitted by the learned counsel appearing for the appellants that all the persons who are still interested in the matter, which relates to promotion, have already been served, and notice to the unserved respondents can be dispensed with. Full stop. It is submitted that the matter will have to be considered for hearing, considered for admission. It is not considered for
My lords, it's
admission.
admitted and an order is issued, my lords. Not to
Sorry?
publish the seniority list is the order, my lords.
We'll
The
consider it
predecessor, honorable predecessor benches issued an order.
in the above.
It's for admission.
The office objections are overruled for the time being. List for preliminary hearing on preliminary hearing
Please, ma'am.
on. Please agree to a date so that everybody is ready.
My lords, sometime after the value holidays.
Because there is no date before
Please,
Diwali anyway.
13th or 14th of November.
Very well.
Leave it,
21st of November.
please.
Please, be ready.
Please, my lords, please.
Murder is there, your lordship.
Yes, intermodal shall remain.
Grateful.
Obliged, my lords.
Overruled for the time being. We'll see whether everybody has to be served. All that we have to look into at the time. Yeah. Don't dispense with, say that overrule for the time being. We'll see. If anybody is required, then we'll see. Yes.
Grateful.
Appellant for week time may be granted. ma'am. To this
54.
steps, please.
Week's time. There again, week's time.
A week's time may be granted.
Yes. Third time. Please pay.
2 days,
What is the court fee to be paid?
200,
12 rupees?
200.
200. Oh,
Will be done.
yes.
Please.
Lord, I may be permitted to make the corrections now, my lord. I'll do it. Meanwhile, notice may be to respondent.
What are the corrections? They can be permitted.
Only the address, my lord, trial court address. Because that is not the correct address. The correct address I have furnished.
Yes, then, but once that correction is effective, issue notice in the corrected address.
Great. I'll do it.
Report of mediation. Yes, wait report.
38 is report.
It is,
Respondent, my lord. The trial court has granted custody to me.
just a moment, is the report available?
NCR may be summoned, my lord. Immediate date may be fixed.
It is not mediate, it is not settled. Item 38.
Report to mediation center to Chitradurga.
Next date hearing is tomorrow, 2 weeks times.
Start.
Please.
Yes, sorry, 39.
Sorry.
Yes.
Matter,
Hmm.
the trust will be granted to me, my lord, and in the meanwhile.
Awaiting TCR. Notice has been.
When the first son died, my lord, because negligence of the wife. The only surviving son, she is not allowed to meet, my lord. I filed it in the year 2017. Date may be fixed, my lord. LCS may kindly be summoned, my lord, send them.
LCS have already been summoned. They have not reached. Yes, let's see.
Convenient date, my lord, some urgency in the matter.
Yes.
Here for the petitioner.
Waiting report.
A date
may be given.
Yes, a date may be given.
Yes. Office objections, third time. Weeks time. Hmm. Page number 12 not forthcoming.
There is one office
Please
objection.
give us page number 12. Yes, 1 week's time.
But the office objection is the name, my lord. Shantamma, Shantalakshmi and Sambhavi. To correct it in the IA and the petition, my lord. I will comply, but notice has to come, my lord. The decree of the divorce has been granted.
Apply immediately, we'll issue notice.
Date may be given, my lord. I
Comply
will do
with
it.
the office objection. Yes. If the office objections are complied with, notice can be. Order, sir. Office objections are complied with, notice can be issued to those. Please comply with the office objections immediately. Yes, notice. Appeal barred by time, second time. Yes, week's time.
Petitioner, Your Lordship, I'll comply with the office objections. In the meanwhile, notice may be issued.
What is the office objection? Only translation.
Translation.
Yes, please make it available. Issue notice in the meeting.
Obliged.
It is submitted that the office objections are being complied with immediately. Once the office objections are complied with, issue notice to the respondent. List on, give a date. Also. Weeks time, 46, 47 weeks time.
48 appears for the petitioner, my lords. That's the,
Non-filing of counter of debits.
my lords, they have not filed it for about 6 months at least, my lords. The matter is on a very,
Issue about
it's a very short point, my lords, where basically, I'm an OBC student, my lords. I take the AIA PGET exam. I get 37 point so and so percentage. The 40%, which was the cutoff, is then reduced to 35. On that basis, they issue a fresh notification, and on that basis, I get admission. I participate in the second round. I get admission in the mop-up round. After about 8 months of the course, they say my percentage is below the NEET percentage, which is required. Although there is a specific notification itself reducing it to 35. So I'm above the cutoff. My lords will kindly see annexure. A is the.
who are permitted to appear in the internal assessment examination.
Yes, my lords.
Awaiting counter of debits. Where is your counter of debits? Who appears? Who appears for the respondent?
What? For the university was Farah Fatima, my lords. They have not filed any counter, my lords. Multiple times they've sought.
Granted by a week to file counter of debit as a last chance. List on.
A date may kindly be fixed,
Yes.
my lords. Please. Oblige me.
Please call that.
For the petitioner, my lord. And that's the facts as such.
Just a moment,
Please, ma'am.
just a moment, please. This respondent number 3 is not the,
Father, he's
Father.
not the biological father. In fact, Mr. Matthews,
but the child was with the two of them.
please, my lords. Initially, my lords together, they have lived together, they've had a child. Then due to some incompatibility, she moved. And there, after facing physical sexual abuse, she got back to him. Respondent number 3 wanted her to come back and live with him because she refused. On the pretext of buying some food, my lords, he takes the 5-year-old girl away.
5-year-old.
5-year-old girl, my lords. And we are just scared because we don't know what, since he's not the father, we do not know what the girl will be facing. My lords. In fact, a complaint was filed and FIR also got registered, my lords, but it's been more than a month and nothing has been done. And the entire thing has happened right in, before the police station only, my lords. And when she goes and complains, my lords, they try to dissect and assassinate her character. My lords, the point here is about a 5-year-old girl that we are talking, my lords.
Yes.
Please get instructions in the.
Yes, we have sought,
The child. There is a child involved.
yes, girl child.
Girl child.
It appears
5-year-old.
he's in Assam without any phone connection. So we are trying to track him. That is the update we've got. Could the Lordship grant us some time? The investigative materials are here. We have summoned them. So,
Can you discuss
about a week.
next week? Next
Yes,
week, we
yes.
can, because the child has been, when was the?
Until
was
2 months
20
ago,
24.
24/9.
until 2 months ago, from their own petition, it appears they were together. So therefore, some attachment the child would have developed. So therefore, it may not be a serious threat. However, my lord,
But-
yeah,
My lords, the very reason why we came out was because she was undergoing some physical abuse, my lords. And knowing that she's not the daughter, we don't want to take that.
No history of any abuse of the child.
No, as of now, no, that's what, my lords, and one submission, what my client says is respondent number 3 is basically from Odisha. So maybe that also, I will provide the.
no, the address is furnished. We have tracked down that. There is a birth certificate also registered by the third respondent, claiming to be the biological father of.
I have produced the birth certificate, my lords.
So, but it is dated
Annexure A.
of recent origin.
In Bangalore?
My lords,
Where is it registered? In Bangalore?
Odisha.
This-
I know Odisha. It could be fabricated, we never know. But then without the consent, they could not have issued.
where it is? Odisha. Odisha. It's shown as Odisha. His name is shown as the-
This petition has But then that is of recent origin.
But
The
my-
original date of.
my client is very much ready for a DNA if your lordship will, for a.
No, nobody disputes.
It is.
Because
what
they are the parents,
Nobody has
he
disputed.
says what
ultimately.
is ultimately.
Please, ma'am.
No issue of any DNA.
Annexure A, page
Not issue at
15.
all.
ma'am.
Yes. Yes, Leonard. This company takes notice for the respondent and seeks trial to get instruction. It is set. Next week, can you please suggest a date? Next week.
10. 7th, my lord.
7/11?
7, obliged, my lord.
Photo ತಗೊಂಡ್ರೆ.
Most for settlement.
I appear for the appellate. I have filed an application on the IA number 6 to add additional ground with the main appeal.
my submission is, your lordship may kindly take this application also along with the main. A date may be fixed for final hearing because the child is suffering from, child is struggling in between the fight between the father and the mother. Lordship may kindly
In all
fix
these
it.
cases, that is what ultimately happens.
That is what.
How old is the child?
7 years.
8
Girl,
years.
8
8
years
years girl.
now. A date may be fixed.
Objections,
fine.
my lords. Copy is given to their IA, my lords. A final
Yes, I-
hearing date was fixed, my lords, on 25/10. However, the matter did not get listed on 25/10. A date may be fixed, my lords.
Final hearing, it will be disposed of, your lord.
There is no chance of any settlement.
No, my lords.
Yes.
That's my objections to the IA, my lords.
Yes, your objections to the IA made available. Same are taken on record. List the IA along with the appeal for hearing on.
First week of November, any date, your lordship. 19 is too long, you know, because it has to be come up on 25th. But ultimately, it was not posted. First week of November, any date, your lordship.
In weekend. We've already listed many cases, that is why. May not be possible even if it is listed to be taken up. List. Till 19th. 1911 at 2:30.
18 is too long, what I feel.
Yes.
I appear for the respondent.
19, your lord.
19.
Much of.
What would like?
I appear for the apparent.
Yes.
Filed an application to seek permission to take the child to Australia because she has got a job of, the decree of divorce was granted, which was challenged by the husband here. As of 13th September, stay has not been continued. And your lordship, there's an urgency because she has to, the time has been extended till December end for her to report back in Australia. So matter has to be heard.
My lord, so far as
No
that
settlement.
No settlement.
settlement has not taken.
Because the
place.
child is being taken away, probably that is also.
No, that is not the reason. There are so
No,
many
my
other
lord,
factors.
in fact, my lord, so far as that application to take the child along with her to Australia, my lord, so far as that matter is concerned, my lord, that is a subject matter of another GNWC case, wherein the application filed by both the husband and wife has been rejected, against which she has preferred an appeal. In this petition, my lord, it is against the divorce, decree of divorce.
Even
So
though under the
if,
special marriage.
my lord,
Act,
that can be clubbed together and all the matter can be heard together and disposed of.
MFA 2268 of 24. My lord, but a date may be given because it never gets posted.
Post along with so and so.
And LCRs also may be called.
Yes, call for the LCR. It's John.
Interim order may kindly be extended.
There is no interim order as on 13/9, my lord. 4 dates have gone. So there was no extension of interim order.
What was interim order?
Interim order there were two factors. One is stay of the divorce and the wife should not leave India. It was, they cannot restrict the movement of the wife.
So far as that leaving India is concerned, my lord, so far
But
as
then
wife is.
4 dates
One
have
minute,
gone.
Just a moment.
So far as she leaving to Australia, last time itself, we have given the statement that we cannot restrict her, there is no impediment. So far as child is concerned, my lord, to that extent, she cannot take the child because without the adjudication of the GNWC.
That, as you said, is a subject.
Yes,
matter.
yes.
Yes.
Please.
Post along with the MFA. Yes.
2268 of 24.
Waiting notice.
Awaiting
for
service of.
after- Yes, list after service is complete.
Great.
What is this? MFA. Hmm.
I'm for the appellants.
Yes.
In first two appeals, my lord, appeal 1284 of 2018 and 3220 of 2018. These two appeals, I prefer the appellants. I would like to just bring to the know, I am just reporting that, my lord, amongst the appellants in the 1284 of 2018, 4 appellants have now died. That is the 4th appellant died, and the 5th appellant is the LR already on record. I'll just pass it on to you. Fifth appellant is already on record. Then 7th appellant, 14th appellant, 28th appellant, and 30th appellant are dead. No. I require some time in between, my lord, to get the LR details and file an application to bring them on
No,
record.
tell us, is there anything surviving in these appeals?
In
Yes,
my
my lord, it
respectful
survives, my
submission,
lord.
they're all
It
covered
survives.
in all aspects.
Lord, it survives. That is something different, and this is.
What is the point which survives?
The point in this case, my lord, is this. The appellants in this case, even in the other cases also, they have challenged the order passed by the Special Deputy Commissioner under the Inams Abolition Act before the Karnataka Appellate Tribunal at the earlier point of time. Their application came to be dismissed on the ground of local standing, etc. That was challenged before this honorable court in a writ petition. In that, the writ petition ultimately came to be dismissed with certain observation, against which we have filed writ appeal before this honorable court, and that in that writ appeal, the appeal was disposed of with a direction that the by setting aside the order of the learned single judge and remanding the permitting the appellants to file appeal before the Karnataka Appellate Tribunal, and Appellate Tribunal has been directed to inquire into as to whether there are any buildings prior to the date of vestings, and inquiry has to be held, and it is only thereafter the matter has to be decided in respect of these parties. Lord, when that order was passed, in between one set of people appears to have, some other person appears to have filed an appeal against the very same order passed by the Special Deputy Commissioner before the Karnataka Appellate Tribunal. That appeal was allowed by the Karnataka Appellate Tribunal, setting aside the very same order of the Deputy Commissioner. That order was challenged by the contesting respondent before this honorable court in a writ petition. That writ petition came to be allowed, it appears, against which they appears to have filed an appeal. That appeal was against which the appellants in the authority appears to have filed an appeal. That has been dismissed, against which some matter is now pending before the Supreme Court. That's what they say.
No, no.
In that, my lord,
Disposed of by the Supreme Court.
my lord, in that petition, my lord, the issue as to whether the buildings that are in existence prior to the date of vesting or not was not an issue at all. That was not decided at all.
Squarely raised and answered.
We are, at any rate, we are not parties. What has happened is, though we have been,
Yes.
none of us are parties, even we could be, even before file an appeal before the Karnataka Appellate Tribunal, the order of the DC was set aside. There was no occasion for us to even file an appeal before the KAT.
Yes.
That is the reason why in these petitions, we have sought for leave to file the appeal. Leave was granted, notice has been ordered.
When was leave granted?
Oh, I'm sorry. The notice has been ordered, so a specific order has not been passed on the application. I'm sorry, I
Previous-
beg your pardon.
I beg your pardon,
Leave is still not granted.
still not granted.
Yes.
My lord, may I just take your lordship through the order on an earlier occasion that has been passed by this honorable court in writ appeal number 6427/2013, which is at page number 317 in the first writ petition. my lord.
Page number?
317. my lord.
Yes.
May I straight away take your lordship through the relevant portion of that order, which is at page number 330, my lord. 329. Having heard the learned counsel for the parties para 9, the only point to be considered is whether on account of any observations made by the learned single judge, the appellants have been prevented from filing an appeal before the Karnataka Appellate Tribunal, even though property purchased by them had buildings which are protected under section 712 of the Act. So far as this point is concerned, there cannot be any dispute with regard to the legal position. If really the structures were in existence on the date of vesting, even if the appellants or their predecessor had not filed an application for regrant, still they can protect their property. Therefore, we are of the view that the learned single judge, without giving a categorical finding, considering several documents produced by both the parties, could not have lately observed whether the properties were in existence or not. In the circumstances, we are of the view that if liberty is given to the appellants to file an appeal before the Karnataka Appellate Tribunal, by directing the appellate tribunal to dispose of the appeal on merits and in accordance with law, and if the appellants are able to show that the property purchased by them has structures even before vesting, in such circumstances, it is for the tribunal to give definite finding whether before vesting the structures were in existence or not, and while doing so, any observation made by the learned single judge shall not influence the tribunal in deciding the matter. With the above observations, the writ appeal is disposed of, granting 8 weeks time for the appellants to file an appeal before the Karnataka Appellate Tribunal, and if such an appeal is filed, the tribunal shall dispose of the appeal in accordance with law without raising question of limitation. Consequently, the order passed by the tribunal and the order passed by the learned single judge are set aside and modified. This was sought to be modified, reviewed by the contesting respondent before this honorable court. Ultimately, review petition also came to be dismissed. This order, my lord, came to
2019 to 2015.
2015.
Yes.
My lord, even before the order in this writ appeal could be passed, it appears some other persons have filed an appeal before the Karnataka Appellate Tribunal. Karnataka Appellate Tribunal set aside the order of the Deputy Commissioner. This was not brought to the notice of this honorable court also, even though they are the contesting parties. It was not made known to us also.
When was that order passed?
My lord, that order came to be passed It was passed on 1/10/2014. 1/10/2014. Order in the writ appeal was passed on 19th February 2015. The review order is also, my lord, is 9th August 2016. There was no occasion for us to go to the go for appeal before the Karnataka Appellate Tribunal. This was the specific finding that has been given by the by this honorable court in that writ appeal.
Yes.
It is in your. It appears this order was challenged. This order of the KAT was challenged in the before the learned single judge in That is in his matter. That is at annexure yes, page 349.
Yes.
Oh, sorry, that is not the one. Oh, sorry. No, not that, not that is right, but that is not the order. That is annexure A, my lord, page number 30, my lord.
Annexure A.
The impugned order in this writ petition, my lord, we are not parties to that. That is the reason we filed the application seeking leave. That is dated 15th February 2018. Page number 30, my lord. This order has been passed by this on the learned single judge, my lord. Following the, my lord, previous order passed by the learned single judge in WP number 51,948 of 2017. That is at page, my lord, it is at page number.
No, paragraph 3 is relevant. This very same order was a subject matter of appeal before the KAT in number 272 of 79, which came to be dismissed by judgment dated 24/12/81. Thereafter, judgment of KAT was subject matter of WP of 2001, which also came to be dismissed by a coordinate bench by order dated 19/10/2001. Said order of the learned single judge was confirmed in writ appeal 7574 by judgment dated 19/12/2001. Subsequently, when judgment in writ appeal 7574 was subject matter of SLP 5258 of 2002, Apex Court affirmed the judgment. It is also that similarly there were other set of appeals which have culminated in order so and so, so and so.
Lord, these are the orders, my lord, which have been passed, not in our petition, not on our
First round.
application, or on our
round.
appeal.
Here round.
That is the first
That
round.
is by the,
Now there is another round.
my lord, that is by different parties altogether. We are not parties to any of those proceedings. We are totally independently, separately filed the appeal
The
before
orders
KT.
are the same.
My lord, that is the reason why, my lord, all problem is now is being created. The either the KAT or the learned single judge before whom the matters have come up, my lord, ought to have seen that all the orders have been, all the matters which have been challenged by the orders that have been challenged by before him ought to have been taken together and order ought to have been passed. Now, question.
The question before my lord would be whether those judgments would act as precedents, whether the facts are similar. We are all owners of buildings and sites. much
Different
before-
different
before
owners.
The date of vesting. My lord, none of these judgments would act as precedents. And my lord, the fact, the learned single judge does not even consider the facts. The learned single judge did not even consider what was the statement of objection that they had filed in that case. When my KAT appeal was allowed, in all these cases, my lord, the KAT appeals they had lost these KAT appeals.
What is WP number 51948 of 2017? 948 of 2017.
That is by another set of another party who claims to be the owner of one yet another piece of
Index
paper.
of judgments which are referred.
Blood, which is at page number 349, my lord.
I'll pass on an index of judgments which are referred in the
349, my lord.
Gangamma,
Yeah,
wife
yes.
of Muniraju.
No, WP
That is what is available in
51948 of 2017, page 349, my lord. Sri J. Raja versus State of Karnataka.
J. Raja. Okay.
Yes, my lord.
31948.
Yes. Not 31, my lord. 519.
5194.
5194.
Sought quashing of judgment dated 13/10/2017.
That is different order, my lord, altogether. Wherein his application came to be dismissed.
after the date of vesting.
he would purchase the site on 12/6/1957. In my index of judgments, which I have now passed on, I have referred to all these judgments which the learned single judge has passed. These judgments would be judgments in person. They cannot operate as judgments in red. Facts are not similar. More importantly, my lord, this judgment is an ex parte judgment, as though I am the contesting party with them. I was not even served. My turn comes right in. Lord, in the first appeal, my lord, what I have filed, Lord, they are the owners of small pieces of land and the building, my lord. Just 200 square feet, 250 square feet, 300 square feet, small. My lord, in fact, now it appears, it is thereafter, it has been declared as slum also. The notification is issued, that has been challenged by them before this honorable court, that matter is also pending.
Yes, where is the finding with regard to the building in
Yes, my
in
lords.
the earlier?
Yes, my lords. May I put it in perspective? The basic order that is in challenge is an order dated 12/7/1999, passed by the Special Deputy Commissioner for Inam's abolition, by which occupancy rights have been granted to my clients in survey number 134.
Yes.
Admittedly, this was an Inam village and the lands are Inam lands, no doubt about that. That order dated 12/7/1999 was put in challenge before the Karnataka Appellate Tribunal by various parties. The Lordship saw para 3 of that order, of Justice Satyanarayana's order, where the first round of challenge was considered, which attained finality right up to the Supreme Court. The second round of challenge to that order dated 12/7/99 was by way of appeal. I will call it appeal number 883 of 2015 before the KAT. May I request my lords to please take that order has not been filed as part of any of the writ appeals. My learned friend has produced it along with memos as far back as in 2020, I think. Kindly take this memo dated 18th March 2020.
March 2020.
18th March 2020.
So you're not.
Is it in the first petition or?
It's filed in writ appeal 976 of 2018. Physical copies will also be there. There are 3 memos. Please take 18th March 2020.
Who fail ಮಾಡಿದ್ದಾರೆ ನಾವು ನೀವು ಮಾಡಿದ್ದಾರೆ.
No, not see. It's there. Okay. 976. Okay.
Please come to page 75 of that compilation, my lords. This, no, in writ appeal 976. No,
Yes.
I am referring to the appellate tribunal order.
Yes, appeal number 883.
Yes, my lords. Please come to page number 75. The order starts from there. I will not trouble my lords by reading the entire order, since the question is squarely on section 9 read with section 12 of the Inam's Abolition Act and the question as to buildings and the findings. Please come to internal page number 12. running page ID.
Yes.
Internal page number 12,
Mm.
bottom of the page. Kindly
Yes.
permit me to read that.
Yes.
The point that would arise for consideration of this honorable court is whether the impugned order passed by the second respondent is sustainable under law in view of not having been given notice to the occupier land pursuant to the land being vested in the government under section 12 of the Mysore Personal and Miscellaneous Inams Abolition Act. Then section 12 is quoted. Section 12, vesting of certain buildings situated in an inam. Kindly permit me to pause here. I did not take your lordships through the narration of facts. The appellants expressly pleaded that there were buildings on the date of vesting. Therefore, we are entitled to retain the buildings under section 9 and 12. I am taking your lordship only through the finding. Then section 12 is quoted there. Please come to the paragraph following the quotation that even prior to the date of alleged vesting of the land in the question, the building under occupation of the appellant was in existence. The second respondent, before proceeding with the case in INR so and so, dated 12/7/99, ought to have issued notices to the existence of tenements before passing the impugned order. These are the express contentions raised. Now, please come to para 14. Page 14, sorry, internal page 14, para N. Please see the contention of the appellant. The appellants have constructed a building and residing thereon since many years, and by virtue of the impugned order, the appellants are jeopardized by the impugned order passed by second respondent deputy commissioner.
Yes.
Expressly raised. Please come to page 15. Top of the page, para O, that the property in question is consisting of residential house carved out of survey number 134 of Binnamangala, and as such, there is no question of filing application for grant of occupancy rights in view of the fact that the property in question is a residential property, and that apart, there was no notice issued by the second respondent at any point of time. Respondent number 3 to 4, who are a beneficiary of the impugned order, have taken false stand. These are the contentions. Now, please come to
Just a moment.
Not mine.
Just a moment, comes. Yes.
Please come to page 16. Para 7. Another ground urged by the appellants is that in view of section 12 of the Inams Abolition Act, and since there were buildings in the survey number in question, the second respondent has no jurisdiction to pass any order of regrant or grant of occupancy rights under the Act. Then please come to the next page, page 17, para 10. That the land in question, that is survey number 134, is situated in Binnamangala village is not in dispute. Similarly, Binnamangala village vested in the state under the provisions of the Inams Abolition Act pursuant to the notification dated 7/7/1958 issued under the Act is also not in dispute. Therefore, it cannot be disputed that survey number 134 vested in the state government. Please come to para 13 at the foot of the very same page. For adjudicating the claim arising under the Act with respect to the vested lands, the condition precedent is that there should be an application seeking regrant of occupancy rights. Admittedly, in the instant case, neither the appellants nor their alleged predecessors in title have made any application before the second respondent seeking a regrant of the land over which they are now trying to assert an interest. That no such application is filed by them is clear from para 18 of the appeal memo. Kindly permit me to pause here. The situation is the same here, except we have identified one category, there is no application either by the present appellants or the predecessors. There is another category where, in respect of some items of property, in 1962, an attempt was made by some people that was rejected by an order dated 22/1/1962, 62 years ago. The application was rejected and that became final.
Yes.
So if it is rejected, they're worse off. Now, my lords, again in page number 18, again section 12 is quoted. Please come to para 17 at page number 18.
Yes.
Questions that we therefore need to consider in this appeal are, these are the questions of law decided. Is section 12 applicable at all to the present case? Even if section 12 is applicable, can the appellants place reliance on it without seeking an adjudication of their claim under the Act by filing the necessary application? A reading of section 12 makes it clear that the said section applies only if the following conditions are fulfilled. There should be a private building owned by a person. That building should be in an inam land. Such building should be in existence on the date of vesting. That building should not have vested under section 7 or section 9 of the Act. Section 7 of the Act deals with buildings belonging to a minor inamdar. Section 9 deals with buildings owned by the inamdar. It is not the case of the appellants that their case is covered under section 7 or 9 of the Act. The same is apparent from a reading of the appeal memo. Now, for section 12 to apply, the appellants must show, as on the date of vesting, there were buildings owned by them in existence in the land in question. The question is how to ascertain whether there were any buildings that were in existence in the land in question on the date of vesting, which is 7/7/1958. The Act and the rules framed under the Act mandates that the Special Tahsildar for Inam's abolition shall conduct a survey of the entire Inam village and submit his report regarding details of the Inamdar, holders of minor Inams, persons in occupation as tenants or in any other capacity, existence of the buildings of Inam lands, etc. in respect of Binnamangala village. The Special Tahsildar for Inam's abolition has submitted a detailed report to the Special Deputy Commissioner for abolition of Inams, which is dated 22/8/1960. Please mark the date, my lord, it is contemporaneous. His report deals with all the survey numbers situated in Binnamangala village. Survey numbers are from 1 to 158. Therefore, these respondents producing certified copy of only the relevant portion of the report, which deals with survey number 134, since subject matter of this appeal is also survey number 134. A reading of this report makes the following points manifestly clear. Copies of the notification under subsection 4 of section 1 have been published in the village. Notice of enquiry in the Inam village had been given to Inamdar and other persons. There are no holders of minor Inams as defined in section 7. There is a building in survey number 138, which has to vest in the Inamdar. Section 9 applies to this clause. Kindly note survey number so and so. There are private buildings in the Inam village with vest in the persons who owned them immediately before the date of vesting. There is no case of agricultural land converted for purposes unconnected with agriculture. The report refers to private buildings and their vesting in persons who own them. The question is there any such private building in survey number 134? Though the report is silent on which survey number in which buildings are constructed, however, there are land records pertaining to the land, details of their land, crops, boundary marks contained in village form number 3, preserved for all the survey numbers in Binnamangala village, that is survey number 1 to 158, showing in which of the survey numbers buildings exist. A perusal of the same shows that private buildings existed on the date of vesting in survey numbers 91, 92, 105, 106, 116, 120, 122, 125, 138, and 134. 140. So 134, there are no private buildings. A perusal of the same also shows that the name of the deceased third respondent, Venkataraju, who is my predecessor, as the cultivator is shown against survey number 134, and the last column also shows there are no buildings in survey number 134. Permit me to read further, my lords. The documents referred to above are prepared at an undisputed point in time and as maintained under the Act and as mandated under the Act and the rules. Such survey and report was necessary in order to consider the claims of several persons under the provisions of the Act. A perusal of the report and the village form number 3 referred to above therefore makes it manifestly clear that there are no buildings that were in existence on the date of vesting in survey number 134.
Yes.
Para 26. It is also clear from the report that notifications are published in the village and notices are also sent to the interested parties. In other words, wide publicity is given before the special Tehsildar conducting the survey and submitting his report. Therefore, it is apparent that if at all the appellants or their predecessors were interested in the land in question, it was obligatory on their part to have approached the Tehsildar or deputy commissioner coming under the act by filing their claim. Admittedly, the same is not done. Indisputably, the report and other documents show that there are no buildings in existence on the date of vesting. Therefore, Section 12 of the Act is wholly inapplicable to the present case. Kindly permit me to pause there. That was part 1 of the finding.
Yes.
Contemporaneous survey in 1960. What is recorded further is another exercise conducted in 1978. Kindly permit me to place that. It is also pertinent to note in this context that the Special Deputy Commissioner for Inam's abolition, by his letter dated 5/11/1978, requested the Assistant Superintendent of Land Records, Bangalore Subdivision, to prepare a sketch and indicate in which survey numbers the constructions are in existence. The specific survey numbers indicated in the letter are survey numbers 135, 136, and 134 of Binnamangala village. The persons who made their claim with respect to these 3 survey numbers are also indicated in the said letter. It is pertinent to note that in the list of persons mentioned in the letter, neither the name of the appellants nor the name of any of their alleged predecessors in title is found. It may be argued that names of respondent 3 and 4 in this appeal who are beneficiaries under the impugned order dated 12/7/1999 is also not found on that list. It is to be noted that the claims of the deceased respondent 3 and 4 came to be considered independently in the proceeding leading to the impugned order because of the direction issued by the Honorable High Court in WP number 7950 of 97. Kindly permit me to pause there. I'll just give an explanation there. Our claim for occupancy rights in 134 was never decided. It was lying in cold storage. So that writ petition 1997 had to be filed and a mandamus was issued by this court to consider our application, and therefore the order came in 1999. Kindly permit me to proceed further. 28. In response to the aforesaid request of the Inam's abolition Special Deputy Commissioner, the Assistant Superintendent of Land Records sent his reply dated 1/2/1978 and also enclosed along with his reply the details sought for along with the sketch. The sketch and the report clearly indicate that constructions existed only in survey numbers 135 and 136 and no constructions existed in survey number 134 and that it continues to be Hiduvali land.
Yes.
The report and the sketch of the Assistant Superintendent of Land Records, which is dated 1/2/1978, also make it clear that no construction existed in survey number 134 on the date of vesting. From this viewpoint also, it is manifestly clear that Section 12 of the Act is wholly inapplicable to the present case.
Yes.
Clear findings, my lords. Absolutely clear findings. I may point out one other legal aspect, which is in para 38 of the same order at page 24, internal page 24.
Yes.
What is pertinent to note in this context is that the appellants in this appeal do not trace their title to any of the inamdars mentioned in paragraph 7 of the Tehsildar's report. Therefore, the very sale deeds on which appellants are placing reliance is of no consequence. After the vesting of the land under the Act, all these sale deeds are also of no avail, and that therefore no reliance can be placed on the sale deeds on which the appellants are trying to place reliance. Section 3 of the Act very clearly provides that for vesting of land free of encumbrance in the state, and therefore, after the date of vesting, only those persons who have acquired one or other right created under the Act with respect to the land in question alone are interested persons. Clearly, appellants do not fit into the same.
Yes.
With these findings, my lords, the appeal was dismissed and the order granting occupancy rights was affirmed. This was challenged in 51948 that my lord saw.
Yes.
That writ petition was dismissed, recording findings that this very issue had been agitated earlier also in 2000, as far back as in 2001, and right up to the Supreme Court, it had attained finality.
Yes.
Now, that 51948 was put in challenge before a division bench. That is writ appeal number 631 of 2018. Same memo? That order, my lords, is page number 19 of the very same paper book. This is order dated 28th March 2018 by a division bench, writ appeal 631 of 2018.
Yes.
After recounting the facts, my lords, let me point out. Before my mistake, my lords, I'm sorry, I should have pointed out. Before I take my lords to the findings in this writ appeal, may I show the memo of writ appeal itself? Because this question of buildings and all that was squarely raised. Again, in the Supreme Court, I'll first show the, please take, there is a memo dated 23/10/2024. No. The memo of writ appeal there. Yes.
Yes.
Did, my lords may go straight away to page 137. May I explain, lords, for your lordship's convenience, what we have done is, we have filed the entire paper book of the special leave petition, and the memo of writ appeal formed a part of that, and the statement of objections that we had filed in the Supreme Court, along with all the annexures, for your lordship's convenience. And the order passed by the Honorable Supreme Court is in a separate compilation. I'll come to that. This document starts at page 137. Would my lords please come to page 147, para 16.
Yes.
The learned single judge failed to notice that as on the date of purchase of the property in question, under the registered sale deed dated so and so, the existence of building as per recitals in the sale deed annexure A. Pursuant to the vesting in government on 7/7/58, all the buildings in the Inam land west to the government as such, second respondent before adjudication for conferring occupancy rights ought to have issued notice as contemplated under the Inam's Abolition Act. So this was squarely raised. Now that writ appeal is dismissed by a detailed judgment dated 28th March 2018.
Yes.
And I'll paraphrase the findings there. The findings are that One, once the lands vest, Inam lands vest in state, pre-income runs, you have to apply and get it. You're not tracing your right to the Inam there. So therefore, you're virtually trespassers. Now, this order in writ appeal was challenged before the Supreme Court, and that SLP is in the very same paper book. It starts at page 39, the memorandum of special leave petition. In that page, building. Please come to page 45,
Yes.
2.5. Whether the Honorable High Court erred in passing an order in contravention of Section 12 of the Inam's Abolition Act.
Lord, we have not given any of those papers. He has been referring, but
It's been signed.
that copy has not been given to us.
It's here, yes, signed.
And we'll give it straight away. I'm sorry, Malak.
It has not been given to us.
I made doubly sure that all of them were served. We are giving another copy. There is absolutely no.
No, in this it is not there. That is different, and what has been served to me is different, and what has been referred to is something.
No, I'm referring to another paper book. This was filed last week.
That is,
My apologies. No, we're giving it to you straight away. So there is absolutely no difficulty. Absolutely no difficulty at all. I'll read from my copy.
you'll have to make reference to this, no?
Absolutely no difficulty at all. In fact, my lords, because your lordships had fixed it specifically today at 2:30, I asked my
But
learned friend to.
Only that you are going to refer this, different book, you are referring with different one, no?
Signature is there.
My learned friend says the filing memo has their acknowledgements, the signatures. And so we're not picking a quarrel on that.
Copy received is also there. Is this the same thing?
1 minute.
That is different, sir.
This is different. That is what. I have not been served anything other than this.
It is the notice, sir.
Same.
210, something has been served.
It's here, it's here, acknowledgement, sir.
No, let's not get into that fight.
10.
2210, what has been served is different, and what is referring is something different to. What has been given to us is something different.
Two memos, my lord. Now we are referring to
It
2020.
is the same. It is the same, sir.
Referring to pages which are not there.
One second. What page did we refer to? No, page 19 is fine. No,
44,
here.
45.
Page 45. Page 45. Yes.
It's different.
One second. There's the documents are there. I think there's some issue.
Sale deed, some sale deed is.
Some issue with the pagination. There's some issue with the pagination. Now, where is the SLP? SLP copy is here. Which para did we refer to?
2.5.
That is page 26 in your. The documents are there, my lords, but I think there's some issue with the page.
So this.
They're all there, huh?
26 is.
I'm so sorry. It was entirely my mistake. It is page 26 of this paper book, 45 in some other paper book. Page 26. Then also come to page 28 of the same paper book, two pages later. Para 5.5. That the Honorable High Court erred in passing. No.
Para 5.
Para 5.5.
The enforcement of the Mysore personal miscellaneous inams.
from page 19, it is jumping to page 37. 20 pages are not there.
There appears to be some confusion with the documents, sir.
I'm so sorry, my lords.
We have the pages.
It's all there, my lords, but there's
No,
some.
this paper book has the pages.
That paper book has the pages. I'll share it with my learner.
It has been served to us is different.
I'm so sorry, sir. So my
Only
apologies.
120 pages
ಅದು
are missing.
ಸಿಂಗಲ್ ಸೈಡ್ ಜೆರಾಕ್ಸ್ ಮಾಡಿರೋದು ಅದು 2 ಸೈಡ್ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು ಪೇಜ್ ನಂಬರ್
No, 20 pages itself are not there. Paya. 20
is, sir.
pages ಇಲ್ಲ. From page 19, it jumps to page
forget it.
35.
Quite evident because the paper book they have is much.
No, that is because it has been photocopied on both sides.
The
This is on
court-
single side.
The court
That's-
of doing this.
Well, my lords,
Continuously, it is the page 19 and the 37, the next page is 37. So
Can
20
we
pages
do
are
this?
missing.
Can we do this? We will photocopy this again, supply it to them straight away, just now. If your lordships would want to carry on with the hearing, I'm ready now, just now, or take it up tomorrow, we'll finish it.
It
We'll
will
give it to
depend-
them in the next 1 hour.
Will depend on them.
In the next 1 hour, it will be given to them.
To verify that.
That do, can we proceed with the hearing?
I'm sharing the copies, they can refer to this straight away.
A reference would be, becomes really difficult for us. The appellants. I think I not to first hear it out. Because our contention is that we stand on a different footing. It is then for the respondents to state that whether these judgments should squarely apply to them or not.
Whether judgments apply or not is the question we are
Yes,
considering.
no,
Therefore, to read the judgments would be the,
please, no. Judgments rendered in some other case between this other parties, my lord, without reference to us.
where is your, where do you say that your property is?
We
According to you.
We say that our properties are there. We have documents from
Survey number
1920.
134
It is in survey number 134.
for Binamangala village.
Yes, my lord. We have said from 1920 onwards, there are transactions, more than 80, 90 transactions before 60 itself has taken place. We have got tax paid receipts for house also. It was within this Bengaluru city municipal area also.
And it be considered at this point in time, after the Supreme Court enters a finding that there are no buildings and section 12 does not apply.
Not what we are trying to say is this, my lord, that findings have come in a case where we are not parties. And this honorable court has given us the permission to go back to KAT. One submission. We went back to the KAT on a permission, liberty granted by this court, approved by the division bench. That has not been challenged. Single judge of this court granted us leave to go to the KAT. A writ appeal was filed. In the writ appeal, this court, the division bench said, yes, you can go there. And after we went there, our appeals were allowed. And a direction was given in our case to find out whether there are buildings or not. There is a specific direction by the division bench of this court to find out whether there are buildings or not. Therefore, an earlier finding, because we were not parties there, we did not know who submitted the report. That report was never put to test. Inquiry ought to have been held. Buildings are there. I have, in my document, my sale deed, I produced the sale deed. The sale deed, the schedule says house building. It is therefore this court said, yes, I can go to the KAT, and then the direction was given by the division bench.
These writ appeals have been
There
pending
are
since
projects,
2018, my lords.
Civil proceedings were there. In the civil proceedings way back in the year 1939, the observations made by the court is that as of 1939 itself,
So
the
question
land.
is not that at all. The question is whether after these findings have been recorded by the, right up to the Supreme Court, that there are no buildings in 134 and therefore there is, section 12 is not applicable, even if everything you are saying is correct. can we re-examine the question here?
No, we, that was pointed out in the earlier round of litigation, this court in Lakshmi's case, which I have produced, in my judgment, which I have given, my lord, in my compilation, which I just passed on in the index.
Council
judgment.
Writ Appeal 6427 is decided on 19/2/2015.
Yes, my lord. Yes, my lord.
Appeal number 883 is decided on 13/10/2017. And from which writ petition is taken 51948 of 2017, which is decided on 5/1/2018. Writ appeal therefrom is decided on 28/3/2018. It is there, from there that the appeal goes.
My lord,
These
that-
are subsequent proceedings before the apex court,
Lord.
where it is found that section 12 is not applicable. How do we go back, even if everything you are saying is correct? Unless you approach the apex court, how can any of this be re-examined by us at this stage? Please tell us.
What I'm trying to point out, but WP 6427 of 2013.
Hmm.
Page 60.
Hmm.
Which arises out of the single judge order, which has granted us leave to go to this court as a petitioner.
We heard you on that. You read it out to us. That is on 19/2/2015.
Yes, my lord.
It is thereafter that the tribunal enters a finding that there are no buildings that,
No.
yes, it is. On 13/10/2017.
Which has been upheld by single judge division bench and
That goes all the way up to the apex court and is upheld. We cannot hear you again on the other question, is what we are saying.
Sorry, my lord, I'm not made myself clear.
Hmm.
The dates are, after this order, 2015 order
Hmm.
of this division bench,
Hmm.
then I would go before the KAT in 967, which is allowed on 1/10/2014.
Hmm.
Against which.
How can that be? How can that be? The order in writ appeal 6427 is on 19/2/2015.
I went to the KAT immediately after the single judge passed the order.
That is on 1/10/2014, you got an order.
On 6/9/2013, I got the order in WP 50708 of 2004.
Council 1/10/2014, you got an order from the tribunal,
Yes, sir.
correct?
Yes.
It is, you say that a review as against the judgment in writ appeal 6427 was dismissed on 9/8/2016.
That is in my appeal, my lord, against my order, my lord.
Whatever.
Yes.
That is, therefore, all that you say happens in 2013, 14, 15, 16.
Yes.
Thereafter, the very same order is taken up in appeal number 883 of 2015.
My lord, that could not have been taken for the reason that, my lord, by then, this DC's order has been set aside. Matter was pending before the Honorable High Court. It was pending before this Honorable Court. That was the order, my lord, that is the order, my lord, at annexure A, what I have produced, at page number. As on 1/10/2014, my lord, the DC order is set aside. My appeal was allowed on 1/10/2014.
Appeal was allowed stating
Yes.
what?
Setting aside the regrant in their favor. And that, 99 order under which they claim regrant. That order came to be set aside only in 2018.
that,
That is the reason.
that order has been
That-
set aside in writ petition.
And which is now challenged.
That's
the reason why, my lord, I said, all these appeals ought to have been taken up together and order ought to have been passed by the
Yes,
KAT.
it hasn't.
Isn't
It
it?
hasn't
has-
been taken
Yes.
up together.
Yes,
Even if there are conflicting judgments.
yes.
Now that one of that has gone all the way up to the apex court, what further can be done in this? Can we
No,
hold
now
that
we are
something
able,
which is found by the earlier division bench is not correct?
we are able to now show from the records that, my lord, the fact in existence are totally different. We have got documents to show that we have been staying there for 6 to 7 decades there. Corporation Khata, everything is there in our favor. 1950 katas are there in our favor. It has come within the city municipal limit. It is not known in whose presence the spot inspection has taken place, who has given the report, whether that gentleman has been. No, these things have to be inquired before the particular DC, my lord. It has to be.
Now, to say that the
Opportunity-
entire matter will go back, all the findings which have gained acceptance up to the Supreme Court should go back to the DC.
It's like this, my lord. Let me give an example. my lord. Supposing he is the landlord. The question is the relationship. Like that, my lord, here what has happened is, we are not questioning that, even assuming that the regrant is in order. 2 acres and 30 quintals, it is a huge extent of land. What we are asking is, our buildings are saved under 9 and 12. And therefore, this court said, since you have buildings, you have a right to demonstrate it before the KAT. That permission was given. And after that permission was given, we went to the KAT. In the meantime, some of them challenged it in a writ appeal. The writ appeal also said, yes, the direction and the liberty given by the single judge is justified. A review was filed. Even in the review, they said so. Therefore, my lord, when a division bench has granted me the right to go back to the KAT and I have succeeded there, all the others, they have lost before the KAT. I have succeeded before the KAT. And then the matter was remanded. I was not even. Remanded to the Tahsildar to verify whether buildings are in existence or not. I have produced sale deed. As far as I am concerned, there was no opportunity for me to challenge that order before the KAT pursuant to the order of this honorable court in the writ appeal. Because by then, DC order was set aside in this writ petition, in this appeal.
Is it your contention that the DC, now considering these matters, can say that the Supreme Court was wrong?
No, we are not saying that. It has to
What
be
else?
individual cases has to
The
be.
thing which has attained finality is that there were no buildings in 134 at all.
On the date of
That is
vesting.
what has, on the date of vesting, there are no buildings in 134 is the finding which has attained finality up to the Supreme Court. Now, what do you think the DC can do? Say that the Supreme Court was wrong?
My lord, those findings have come, my lord, in our absence without
Wherever
notice
it
to
has
us.
come,
We have
wherever
not.
it has come, however it has come, those findings have gone up to the apex court, attained a finality.
Now we are left.
You to have been vigilant if this is your contention at the relevant times, it was for you to have been.
Where is
vigilant and taken a
No
jump.
question of vigilance does not arise for the simple reason that the writ appeal was filed in that permission has been granted. We are supposed to file an appeal before the KAT, but that order itself was set aside. That order was challenged in this writ petition in 2018 that came to be set aside. That is challenged before this honorable court.
Yes.
In parallelly, some other proceedings, some findings are recorded in which we are not parties. We are not aware of any of those proceedings also. And in this case, specific direction is that there must be an inquiry to this, to the effect that whether there are buildings or not, in so far as the parties to this petition is concerned.
You understand the contention?
Has really whether it has presidential value or not. One of the first principles of the ratio decidency is facts should match. My lord, on facts, without examining the facts, my lord, there they say, all they say is, a report is given showing that in 134 there are no buildings.
A statutory report which is required to be filed before a vesting
report was
occurs.
filed in a case where I am not a party. Whereas,
Who are you?
my lord,
Then the question would be, who are you? How did you come in possession of the property?
I have come in possession of property by virtue of a sale deed.
Long prior to the date of vesting,
from 1930, 1940, we are there. I've fetched the sale deeds also. In fact, way back in 1962, one of my predecessor in title has challenged it, that they themselves produced it. So therefore, my lord, I am not a person who is claiming through the inamdar. The other case, my lord, she was a person who was claiming.
that is the that makes the difference. That is the golden thread that runs through all the cases. Even if a person puts up a construction, assuming there was a construction on the date of vesting, unless he claims some vestige of right traceable to the inamdar, he cannot claim benefit of section 12. And that finding has attained finality right up to Supreme Court. And let me point out, my lords, Annexure S in writ appeal 3220, the order of 1962 that I mentioned, the authority specifically records that all those people who claimed rights in the buildings, they admitted before the authority that we are not tenants, we are not paying any rent. So unless they claim any vestige of right traceable to the inamdar, even assuming there were buildings, section 12 will not operate at all.
Section 12 make a
Every private building other than building.
Section 9 and section 12.
Section 9 and section 12.
Nine says land and buildings to west in the Inamdar. Every Inamdar shall with effect and on from the date of vesting be entitled to register as an occupant of land.
Just a moment, please, just a moment. This is the Mysore Personal and Miscellaneous.
Personal and
Yes.
miscellaneous.
Abolition Act.
You held it. You know,
Yes.
Every Inamdar shall with effect on and from the date of vesting be entitled to be registered as an occupant of all lands other than one, communal lands, wastelands, boma lands, forest lands, tank beds, mines, quarries, rivers, streams, tanks and irrigation wells. Two, lands in respect of which any person is entitled to be registered under section 4, 5, 6, 7 or 8 and lands upon which have been erected buildings owned by any person other than the Inamdar. So these, he can be registered of land other than.
other
So
than the
these
inam.
are exempted. Then kindly come to 12, please.
Every building situated within the limits of the Inam, which was owned immediately before the date of vesting by the Inamdar shall, with effect from such date, vest in the Inamdar.
Inamdar.
Which was owned immediately before the date of vesting by the Inamdar shall, with effect, vest in the Inamdar. Means Inamdar other than a holder of a minor Inam. Yes. Then 12. Every private building other than buildings which vest under 7 and 9, situated within the limits of an Inam shall, with effect on and from the date of vesting, vest in the person who owned it immediately before that date. Any
Yes.
dispute relating thereto shall be decided by the tribunal and such decision shall be filed.
There are two things there, my lords. One is that the person who owned the building, that has been interpreted by a division bench headed by Honorable Ladyship Justice Nagaratna in a recent judgment, SM Karnappa's case. Of course, that arose under the religious and charitable inams parimateria provisions. What is section 9 here was section 7 there. And what is section 11, section 12 here was section 11 there. And that has been held to be that if a tenant puts up a building, then he gets a right. I'll cite that judgment. I'll give a copy of that judgment.
Here-
And the second thing, most important thing, please see the last portion of section 12.
Hmm.
Even if they have a building on the date of vesting, they still have to make an application before the authority under the Inams Abolition Act. Having not done that, they have no claim at all. And that is a finding again recorded, not only in this case, but also in that case. And that in Karnappa's judgment, my lords, the division bench has clearly said that even to claim any right under section 9 read with 12, one has to make an application and that has to be adjudicated. None of these appellants have filed any application. Like I said, in some cases, in some items of property, there was some attempt in 1962 that was dismissed. 62 years later, there is no challenge to that. So they're worse off.
They have themselves filed that application. We have filed that application.
Just a moment. Yes.
One submission, section 7 deals with regard to the Mysore Millard Personal Inam Abolition Act is concerned. Whether the buildings belongs to the minor inam, section 7 will apply. Section 9 is concerned, it belongs to owned by inamdar. If these two are not there, section 12. Means Millard, they are claiming section 12. But 12 invoking, 4 conditions must be present. But one condition, first Millard is section 12 is concerned. A person, there should be a private building owned by a person. Number 2, there should be an inam land. Number 3, Millard, is in existence as on date of vesting. Number 4, Millard, the building should not be vested in section 7 and 8. But all these provisions is not contemplated because they are not, but first of all, they are not claiming, they are claiming under section 12. But second thing, Millard, is that admittedly in 2017, the judgment of the KAT, Millard, in 883 appeal, the report clearly indicates that in survey number 134, as on the date of vesting of the land, the date was given in the survey report, no buildings are in existence at all in survey number
Only agricultural land.
only agriculture land, not only based on that report, but also on the support of the revenue records discloses that which crops are cultivating by the landowner as on the date of vesting of the date. But that is concerned, Millard, is clear finding by the KAT. That KAT was challenged before this honorable court. This honorable court has confirmed, writ appeal also confirmed, Supreme Court also confirmed. They are also again claiming that section, our lands are private buildings, we are the private section 12. Section 12 question, Millard, is already decided by this, all the courts. There is nothing in this matter, Millard, only to dismiss their appeals.
Yes.
ಹೇಳ್ತೀರಾ? ನೈನ್ಟೀನ್ 39 ಸೂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದೆ. 1939 ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
And Article 142, Millard, is binding on all. Millard, the Supreme Court, Apex Court already passed the.
Yes, madam.
You don't have anything further to state. Hear them on what they have to state and if there is.
Yes, my lords. If there is anything to respond, I will take my chance. If necessary, my lords, I'll give a copy of that Kannappa judgment where that issue is also. We'll just place a copy of that.
The memo of subsequent.
I have to be nice.
1 second. I'm so sorry. Since your lordships asked for copy of that, I will not read that. I will just indicate the para numbers.
Please.
Let me just indicate the para numbers in that. Let's para 135. Para 167 small b, 167 small d, 167 small f, para 173. Those would be the relevant paragraphs there. And finding is very clear, and that was a case where a ladyship has gone to the extent of saying that Inam's Abolition Act would apply even to non-agricultural lands. And the distinction drawn between the Karnataka Land Reforms Act and the Inam's Abolition Act is this, that the Land Reforms Act is an agrarian reform law, where the object of the statute was to abolish absentee landlordism and to give rights to the actual tiller. In Kannada, we say, Uluvovenige bhubi. That is the saying. Whereas the Inam's Abolition Act abolished Inams in tune with the constitutional principles, and not only the tenants, but the Inamdar was also given rights under the Inam's Abolition Act. So it is not purely an agrarian law, agrarian reform law. And there may be instances like the one that arose in that particular case, where the Inamdar leases the land to a person for non-agricultural purposes. There, that person was running an automobile garage. Right in the heart of the city, it's a very famous place. So the finding is that if such a tenant puts up a construction, then he is entitled to apply under the Inam's Abolition Act to the competent authority and get occupancy rights. So two things. One, he has to claim his rights to the Inamdar. Number two, he has to apply. These are the two requirements. I'm
Yes.
grateful, Manoj. I'll respond to if necessary.
Yes.
May I just pass on some list of dates, my lord, the manner in which the entire proceedings have taken place. Lord, respondent number 7 to my lord, one Mr. Muniraju
Yes.
and Ramaraju, my lord, along with 5 persons, my lord, makes an application seeking mutation of the property bearing survey number 130, 134, 135. Wide application dated 4/12/1959.
Yes.
Which application I have produced as Annexure B to the writ appeal. But on 12/2/1960, the first application applicant sought to withdraw the application. Then, Millard, in 1962, about 18 occupants of bits and pieces of land, house sites and buildings, Millard, have made an application. That too in survey number 134 only, made application before the Special Deputy Commissioner, which has been rejected, stating that adjudicating the right and title of, to buildings or lands converted for building purposes is outside the scope and jurisdiction of the Special Deputy Commissioner, and this order has become final. Then on 25/8/1978, pursuant to an application made by 7 more persons claiming re-grant based on the lease deed dated 5/7/1902, including the father of these 2 persons who have filed the application on 4/12/1959, my lord, that is Mr. Muniraju and Ramaraju, made the application for re-grant, and in respect of survey number 130, 131, 134 and 136, even including 134 also of Binamangala village, and the Special Deputy Commissioner rejected the claim of Doddama Arappa, that is the father of the other 2 persons, my lord, who made the application on 4/2/1959, 4/12/1959, stating that it is not covered under the lease dated 57/1902 and granted occupancy rights in survey number 135, measuring about 15 guntas, and 136, 1 acre 38 guntas, totally measuring about 2 acres 13 guntas, to Munitayamma. This has become final. Later, my lord, on 25/3/1997, Muniraju and Ramraju files the writ petition before this honorable court. That is the writ petition, my lord, as the senior has referred to, WP number 9850 of 1997, seeking a writ of mandamus to the Special Deputy Commissioner and the Land Tribunal to dispose of their application, my lord, which is at serial number 1, my lord. That writ petition came to be disposed of with a direction to dispose of the application. The Special Deputy Commissioner initiated the proceedings as if it is a revision petition under section 136(3) of the Land Revenue Act. But the proceedings have been initiated like this, and against an order of the Assistant Commissioner, Bangalore North Division, dated 23/2/1998, and continued the proceedings. I have produced that order sheet also, my lord. This is how the proceedings have been initiated. On 10/3/1999, a statement of Muniraju was recorded, and for the first time, my lord, he claims that the land was taken on lease in 1902 as per Exhibit P1 that has been produced before the Special Deputy Commissioner, and he and one Mr. Ramraju, his brother, are the legatees under the will allegedly executed by his father as per Exhibit P4. For the first time, the will has come in. For the first time, on the basis of the will and the lease, they are claiming. In the application, my lord, they claim to be the joint owners. I will take your honors through that document, lordship, through that document also. On 12/7/1999, Special Deputy Commissioner passed the order granting occupancy right in respect of lands in survey number 130, 131, and 134, totally measuring about 4 acres 20 guntas, jointly in favor of Muniraju and Ramraju. That is the contesting respondents now, my lord. 4 acres 20 guntas. The application, my lord, your lordship may kindly see the application what has been filed is in respect of survey number 130, 134, and 135. The grant made is 130, 134, 131, and 134. It was jointly, it was given. Then on 16/9/2003, many of the appellants before your lordship have filed an writ petition before this honorable court in WP number 7315-30 of 2000, and the same was disposed of to avail the alternative remedy of appeal under section 28 of the Inam Abolition Act. On 39/2004, many of these appellants have filed the appeal. Appeal number 1315 of 2003 before the Karnataka Appellate Tribunal. That came to be dismissed. With a leave application, we filed it. That came to be dismissed. That order was challenged by these petitioners, my lord, appellants, my lord, in writ petition number 50,708 of 2004. That is the writ petition, my lord, which was ultimately, my lord, taken in appeal. That order in the writ petition has been disposed of certain directions, permitting us to file appeal before the KIT. On 19/2/2015, writ appeal was filed by, in the writ appeal filed by us, this honorable court has been pleased to set aside the order of the learned single judge and specifically making observation to the effect that the structures, it has permitted us to produce document to show that structures were existing even before the date of vesting. On 1/4/2014, respondents 3 to 6, that is their, my learned friends, parties, my lord, they have filed the appeal. When my writ appeal was pending before this honorable court, they filed the appeal in appeal number 967 of 2013 before the KIT, challenging the very order of the Deputy Commissioner. The said appeal came to be allowed on 1/10/2014. Then that order was challenged on 19/2/2015, we were not aware of this order passed in appeal number 967. We had filed the writ appeal 6427, that is that has been referred to, and ultimately this honorable court has been pleased to dispose of that writ appeal, setting aside the order of the learned single judge, my lord, with the directions which I have already read it to your lordship. In the meantime, my lord, they have also filed a review petition that came to be dismissed. It is thereafter only, my lord, we have come to know about all these writ petitions, my lord, the order that has been challenged before this honorable court. Now, having regard to these peculiar circumstances and having regard to the order that has been passed by this honorable court is writ appeal, I have had no opportunity to prove anything before the KAT. There was no opportunity for me to go before the KAT also. I could not even file appeal before the KAT also, despite the permission that has been granted by the honorable court. In the meantime, parallelly, some other writ petitions have been filed in some other case where certain observations were made. Based on that, my lord, now my rights, my liberty, the permission that has been granted by this honorable court, my right of appeal is taken away. I am not in the position to go before the KAT and establish anything. I have got the documents to show that from 1920 transactions have taken place. This was not in agricultural land at all. It was a fully developed land. It was within the city limit to municipal limits of Bangalore City Corporation also. The properties have been assessed for taxes before the corporation. The buildings were there. Several buildings were there. Way back in the year 1939 itself, the entire property was divided into sites and properties have been sold.
Yes.
It is under these circumstances, my lord, I have come before this honorable court, challenge this order by seeking leave. My lord, since I had no opportunity to prove anything about my case and my properties, the existence of my property, since when my property is there, I was not able to prove anything. I am staying there, I am residing there for more than 6 to 7 decades we have been staying there.
Yes.
This is the fact situation behind my filing my writ appeal. And now, unless my leave is granted and I have been permitted to file an appeal before the KAT, insofar as my interest in my portion of the property is concerned, we are all the owners of properties measuring about 10 by 15, 10 by 20, 10 by 30 by 40, some few 40 by 60. All small holders of properties, my lord. We don't have any other property. This is the only property we have been enjoying it over the period. Even long before the vesting also, none of these persons were in possession of the property. The first criteria for granting the regrant, the first criteria for regrant is that a person must be in possession, whether it is as a owner or as a tenant. Lord, kindly see the application that has been filed, which is at page number 49, annexure B. (1284) of 2018. Annexure B, page 49.
Yes.
This is supposed to be the application filed on 4/12/1959 by 7 persons seeking joint occupancy, seeking jointly the mutation in their name. 1, Mr. K. Dasappa, 2 is Venkatraju, 3 is Muniraju, 4 is Bodappa, 5 is Ramraju, 6 is Muni Narsimhaya, 7 is Peddamarappa. They say that the above petitioners jointly own survey numbers 130, 134, and 135 situated in Kayamgutta, Binamangala village, civil station, Bangalore area, civil station area, Bangalore. These are dry lands. There are some houses in these survey numbers from time immemorial. They themselves admit that in their application. These petitioners are in possession and enjoyment of these lands from the time of their ancestors. The total extent is 3 acres. The claim is only in respect of 3 acres out of these 3 survey numbers. Since the above village has been taken over by government, these petitioner request that these 3 survey numbers may kindly be transferred in their names and they be registered as joint owners of these 3 survey numbers at an early date. This is how the application stands. 7 people claim as joint owners and seek joint registration as joint owners only.
Yes.
Let next page, page number 60, one of the applicant, withdraws his application. Then a additional statement was recorded saying that below it, on 12/12/1960, it is stated that survey number 136 is Kharab House. It is in my possession. The petitioner has raised one unauthorized hut recently. Hence, petition may be rejected. That is what one of the person says, and he seeks for withdrawal of his application. Page 51.
Yes.
The Kannada version is typed here, English version. Translation, page number 50, Kannada version is translated at page number 51.
Yes.
The person shown in the applications are my relatives. The land shown in survey number 130, 134, and 135 do not belong to me. These can be deleted from my application. I have constructed a house in survey number 13. There are 3 huts, etc., etc. That is how he sought to withdraw. This application was not decided. Annexure C, is the writ petition that they have filed. Only these 2 persons, out of 7 persons, only Muniraju and Ram Raju. Your Lordship may kindly also see under Annexure B, these applications have been filed by the guardian of these persons. They were minors then. As on the date of application, they were minors. The writ petition in 7950 was filed. In that writ petition, they was only sought for mandamus to the Tahsildar, the Deputy Commissioner to page 57 is the relevant paragraph, where the prayer is there. Mandamus directing the respondents to consider the applications of the petitioner as per Annexure A and dispose of the same in accordance with law. It is further just and expedient that this Honorable Court may please to pass an order directing the ends of justice, including cause. That's all. That is the ultimately in that writ petition, order came to be passed. Order, Your Lordship will get it Annexure D.
Yes.
There at page number 65, para 2. The petitioner submit that they have filed application under section 4 of the Karnataka Personal Miscellaneous Anonymous Abolition Act, and that has not been disposed of by the respondent despite 3 representations made. The respondents have not replied to the representations of the petitioners. The petitioners have not produced the acknowledgement to show that he has made the representation. Taking into consideration the overall facts of the case, respondents are directed to dispose of the application expeditiously as possible. That is the order. It is pursuant to that, the proceedings were for the first time, initiated as if it is a proceedings under the Land Revenue Act. Section 136(2) of the Land Revenue Act. The relevant the page annexure F is the proceedings sheet of the Deputy Commissioner. Your Lordship would get the translated copies at page number 79 onwards. There, the applicants are only Venkatraju, Muniraju. The chairman, Land Tribunal, Bangalore North Taluk is the respondent there. It is subject, it says that appeal bar division, appeal for revision, it is not division. Revision, application under section 136(3) of the Karnataka Land Revenue Act against the order dated 23/2/1998 passed by the Assistant Commissioner. This is how, my lord, the proceedings have been initiated. It was not a proceedings initiated under the Inams Abolition Act at all. It was not taken as a proceedings under section 5 of the Inams Abolition Act.
Please come to page 80. The order sheet on 16/3/98 states, advocate for
the
applicants was
who are
present.
Instructed
Applicants to submit an affidavit to the effect that the applicants have submitted their application under Inam Act, informed to write letter about this affidavit to Tahsildar, Bangalore North.
yes.
Then Muniraj present filed affidavit, Wakalat on behalf of impleading application, informed that Wakalat will be submitted. Impleading application filed. It is considered as an application under section 4. Advocate for applicants present, impleading applicant not present. Advocate for applicants has expressed his objection to the impleading application. There is no provision for impleading. Requested for evidence, statement recorded. Yes, it is considered, it is an affidavit is obtained stating that it is an application under section 4.
Even if it is taken as an application under section 4.
Now, this is your document, counsel.
Yes, my lord. Yes, my lord.
Yes.
Even for argument's sake, if it is taken as an application under section 4,
Hmm.
my lord, there are 7 applicants who have filed the application
Hmm.
and they sought for joint grant of re-grant in the joint names of them as the joint owners of the property.
Hmm.
At this point in time, there was no claim based on the fact that they don't claim that it is based on either a lease or through based on a will or as a either as inamdar or tenant. Neither the inamdar nor the person and in what capacity the petition proceedings have been initiated is not forthcoming from here.
Yes.
Inamdar is also not a party. These are the mandatory requirements, my lord. In fact, the application is also required to be filed in the prescribed form only.
We are considering an order which has gone all the way to the apex court. We are repeatedly
Lord,
considering.
the
orders
reason
which
why
are-
I am making this submission, I would not have made this submission for the reason that I had no opportunity to go to KAT. The appeal, I was not able to go before the appellate court and make my submissions on this. Without hearing me, without notice to me, or without me being a party, some order is passed and it's thrust upon me.
Yes.
What is my plight?
Yes.
The case built up was not as per the application that has been filed. There was no particulars that was forthcoming. Now this order is sought to be thrust upon me without giving me an opportunity of filing appeal before the court and appellate court and challenge this order. I would only say that
Yes.
these judgments, whatever that has come, my lord, can be said to be a it is not a judgment in a rem as such. It is only a judgment in person. And it binds only those parties who are parties to that. And
Yes.
whatever the finding that has been recorded, my lord, those findings do not bind me. And it has to be again retested before the authority is concerned. After
Yes.
giving me an opportunity.
Yes.
All notes I'm giving.
Yes.
Just have a look at these notes.
Yes.
The date of vesting is 7/7/1958.
Correct. 58. 58.
My case
Yes.
that we are the owners of three properties.
Mm.
But they are the registered sale deed,
Mm.
22/6/1929, 12/8/1955, and 5/5/1939.
Your properties are also admittedly in survey number 134.
Yes. In 34.
Yes.
Next para assignment.
Mm.
The appellants are owners of three residential houses, survey number 134, presently Vinamanga, Old Madras, Vinamanga, and they are residing except residential properties and they are purchased prior to the date of the the occupancy right. Survey number was granted in favor of the respondents 3 to 6.
Mm.
The present appeal, they are responding 3 to 6 by the Assistant Commissioner in proceedings 13 of 1997, while order dated 12/7/1999, Annexure B, my writ appeal.
Mm.
My contention is that they have seen these orders suppressing the fact that these buildings were in existence. These, this grant of occupancy rights in respect of 2 acres that includes my properties also. And we were not parties to those proceedings. Therefore, we filed WP 5078 of 2024 before this court.
Mm.
Contending, my lord, that their building, our buildings are exempted and saved under section 12 and could not form or be included in the grant of occupancy rights. My lord, in the petition, we are also stated that we are not purchasers from the original land, buildings are saved under 12 because we are owners of property.
Mm.
This WP 50708 was disposed of on 6/9/2013 with the observation that if we were able to demonstrate that the buildings were in existence prior to the date of vesting, then they are at liberty to approach the appellate tribunal within 1 week. My lord, this is noticed that in my writ appeal, it's at page 161, 162 of the writ appeal.
Mm.
Internal page 47 and 48 of the writ petition. My lord, this writ petition, which is granted
in WP 50708 is confirmed in writ appeal number 6427 of 2013 and 1467-71 of 2014 dated 19/2/2015, that is Lakshmi versus State. So I produced along with my list. And also the review petition. It's review petition which my friend filed. Well, in the meantime, we filed 967 of 2013 under section 28 of the Act for the KIT questioning the grant order dated 13 of 97 and dated 12/7. The same is annexed. This is allowed on 1/10/2014. So my appeal 967 is allowed on 1/10/2014. Setting aside the orders passed in INA CR 13 of 97/98.
Yes.
Against which writ petition, which is now 48024 of 14 is filed.
Yes.
Which is allowed on 15/2/2018. Therefore, my lords, as between the date 1/10/2014 to 15/2/2018, this order was.
Yes.
Being set aside was not in force.
Yes.
Therefore, my lord, the order which they have obtained in 883, which they
Yes.
read out, they were obvious, they were parties. There were parties in these proceedings also. They did not inform the KIT about the order being set aside.
Yes.
So therefore, they were not before that when the order was obtained in that KIT in that matter. They have suppressed the fact that this in 967 the order was set aside.
Yes.
So anything that transpired as between 1/10/2014 to 15/2/2018 is a nullity.
Yes. Yes.
Then, my lord, insofar as WP 48024 of 14 is concerned, my lord, the single judge would set aside the order passed in appeal number 967 without considering the order of the appellate tribunal on merits. My lord, or hearing their, my lord, I was not even heard before the learned single judge. My lord, it's an ex parte order. Virtually, it's an ex parte order.
Yes.
But then, all that the learned single judge does is, learned single judge would place reliance on the judgment of the Honorable Court in WP in Raja's case, and Narasimha's case. And, my lord, insofar as Narasimha is concerned, my lord, he is the grandson of one Dasappa, he is a rival claimant. So therefore, my lord, he does not stand on the same footing as me. Then, my lord, in the other WP 988 of 2002 and WP 655 of 2002 and SLP so and so, is filed by one Ramareddy who claimed that he was the purchaser of a site measuring 20 into 30 feet under registered sale deed dated so and so. But this writ petition also was dismissed, placing reliance on the earlier writ petition 4300 of 2001 filed by one Gangaya, who had purchased site number Pata number 19/4 under a sale deed dated 10/1/97. My lord, Gangaya's case was dismissed as he could not show title of his vendor. And Gangaya's writ appeal and SLP also was dismissed at the stage of admission. My lord, WP 998 filed by Ramareddy was dismissed without examining the merits, but on the ground that similarly placed purchaser Gangaya was dismissed. So, my lord, so a single judge does not even examine the facts of any case, my lord. But then it is to be pointed out that Narasimha, the writ petitioner in 3884 of 94 of 2001, Gangaya in WP 4300 of 2001, WP 988 of 2000, Raja Sharat Kumar have claimed to be owners of land measuring so and so, which formed portion of a larger extent which they purchased on so and so. Their writ petition was filed being agreed by the dismissal of their appeal KIT filed under section 28 by the KIT Act. The said writ petition was dismissed, placing reliance on the orders passed in the above three writ petitions of Narasimhaya, Gangaya and Ramreddy. The single judge was of opinion that the orders passed by the Special Deputy Commissioner had reached finality in the aforesaid three litigation, and there was no need to go into the correctness or otherwise of the judgment dated 13/10/2017 passed by KAT in appeal number 883 of 2015. So therefore, my lord, this KAT appeal itself being disposed of on 13/10/2017, as on which date the order itself was not in sustenance, having regard to the fact that it was set aside as far back on 1st of October 2014. My lord, anything that transpired as between 1/10/2014 to 15/2/2018 is of no consequence. My lord, all these petitioners had filed an appeal on section 28 before the appellate tribunal, questioning the grant of occupancy right in favor of, and their appeals were dismissed. But my appeal has been allowed, against which they have come up before this court.
Yes.
My lord, and therefore, my lord, the single judge therefore was not justified in relying on an appeal, take the order dated 13/10/2017 and appeal number 883 of 2015. My lord, all the four writ petitioners were unsuccessful, my lord, before the Karnataka appellate tribunals. And therefore, I stand on a different footing, totally on a different footing. I have succeeded. All what the division bench has said, and even in the KAT, my appeal is success, when I succeeded, all that the appellate tribunal has said is remanded the matter back to the Tahsildar. No hardship would be caused to them. My lord, valuable, immovable properties are involved.
Yes. Can we? You want to argue? We cannot, we have a meeting at 5:15.
Just to set the record straight, I'm passing on this chart, which covers all the four writ appeals. The last column there, I mentioned 1962 order. In respect of some items of property, their predecessors had made a claim that was rejected. Others did not file at all. So those who were rejected, they are worse off. So just to set the record straight, I've stated that. That's the last column. I'm great.
If anybody wants to argue anything further, we'll list it on another day. Please look at the list.
Not in this matter, some other matter.
Your lordship,
Yes.
your lordship, one
This one
submission,
we-
lordship. There's been cause list 2, serial number 8, your lordship. State for final hearing. Parties are present, your lordship, on GNWC matter, custody matter, your lordship. Kindly fix a date for.
These two dates.
Please, your lordship. And interim order kindly be extended.
Fourth, I am not.
Interim order.
I'm not.
Interim order is there.
Sixth or seventh of.
Lordships, kindly, my lord.
Tomorrow.
ನಮ್ದಿನ್ನು ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ನಮಗೆ ಇನ್ನು ಆಗಿಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ ನಮ್ದು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು ಅಂತ ನಮ್ದು ಮುಗುದಿಲ್ಲ ಅಂದೆ ನಮ್ದಿನ್ನು ಮುಗುದಿಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದೆ
Order has not been uploaded. Be done today. Give the,
Your
take the
lordship,
number.
kindly, my
and
lord.
numbers. So, I've corrected everything.
Your lordship,
Next
kindly,
date.
my lord.
Next date,
Habeas
please.
corpus matter could take
Next
up
date.
tomorrow.
Deeply grateful.
Habeas corpus matter can take on tomorrow, my lords.